and then I'll get each of you to introduce yourselves. So thank you for coming this morning. Good morning, Richard and Renee, who are both online. First of all, I just want to declare that the opening of the public hearing of the Joint Standing Committee on Implementation of the National Redress Scheme inquiry into the continuing operation of the National Redress Scheme. I would like to acknowledge the traditional owners of the land, the Ngunnawal and Ngambri people, and pay my respects to elders past, present and emerging, and any First Nations people that are here today. And I remind all present that as Chair, I will ensure that the proceedings are conducted in an orderly, respectful and courteous way. This hearing will be audio broadcast and the transcript of the proceedings will be published on the Parliament's website. And I invite all members to introduce themselves.
I'm Dennis O'Brien. I'm the Chair of Australian Catholic Redress Limited.
Hello, Dennis. Nice to meet you.
Helen Delahunty, I'm a Director on Australian Catholic Redress.
Beautiful.
Greg Bennett, Bishop of Sale, Vice President of Bishops' Conference and the Chair of the Bishops' Commission for Professional Standards and Safeguarding, which relates to our company. Thank you.
Thank you.
Paul King, Manager Australian Catholic Redress Limited.
Thank you, Paul. Renee, do you want to introduce yourself and then Richard?
Yes, of course. Thank you, Chair. I'm Renee Coffey. I'm the Federal Member for Griffith in Brisbane.
Hi, good morning. Senator Richard Dowling, Senator for Tasmania.
Thank you. So I now welcome representatives from the Bishops' Commission for Professional Standards and Safeguarding of the Australian Catholic Bishops' Conference and Australian Catholic Redress Limited to give evidence today. You've all introduced yourself for the benefit of Hansard. This hearing is a legal proceeding of the Parliament and it has the same standing as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Do you wish to make an opening statement? But before we do, Dean Smith has... Dean, would you like to introduce yourself?
Thank you very much and good morning, Chair. My name is Dean Smith, a Liberal Senator from Western Australia and the Deputy Chair of the Committee.
Thank you, Dean. So who would like to give the opening statement? Is that you, Dennis?
Well, thank you, Chair. Yes. Representatives of the Catholic Bishops' Commission for Professional Standards and Safeguarding and Australian Catholic Redress Limited are grateful for the invitation to appear at this hearing to supplement the joint written submission to the committee which both entities made. The two entities have different roles. Australian Catholic Redress Limited is the representative body for all the Catholic dioceses in responding to and liaising with the National Redress Scheme in connection with applications made to the scheme. The Bishops' Commission is the group of bishops given the vital task of leading the Church's national work to ensure child safety in the Church and to strengthen its safeguarding culture, so that, to adopt some recent words of Pope Leo, the protection of minors and vulnerable persons is seen as a natural expression of Christian faith. Both ACRL, if I may use that shortening of the company name, and the Bishops' Commission are committed to ensuring that a just response is made to survivors of the legacy of child sexual abuse. The Act prescribes a sunset day for the scheme and specifies that new applications can't be received in the 12 months preceding that day. As the prescribed sunset day is 30 June 2028, the last day for applications is 30 June 2027. Section 93 provides that rules under the Act may extend the sunset day beyond 30 June 2028. But as you'll see from our written submission, we submit that the life of the scheme should not be extended. Mindful, however, of our commitment to ensure just outcomes for survivors of historic abuse within the Church, we are comforted in making this submission by the assurance given by the Department of Social Services in its submission to this committee that it will deliver outcomes for all valid and eligible applications received by the 30th of June 2027. We can, in the hearing this morning, expand on why we consider the sunset day should remain 30 June 2028. Our written submission deals also with the problems our diocese have been seeing in recent times with determination of cases by independent decision makers. It may be that some of the issues we refer to in our submission are being addressed by the initiatives which DSS indicates in its submission have been taken or are in hand in reducing delays in decision making and for strengthening decision making. We certainly trust that that is so. The significant financial commitment which our diocese made to the scheme, and we were original parties to the scheme, really, or amongst the original ones, but that financial commitment which we made rested on the premise that payments would be made in cases where there was a reasonable likelihood that the applicant was eligible for redress. Reasonable likelihood, in our view, means that the material before the independent decision maker must establish that it is more likely than not that the abuse occurred. It is a major concern to many of our dioceses that cases have arisen in recent times where a finding of eligibility has been made in circumstances where, at best, the facts would suggest no more than a possibility of the abuse having occurred. With those opening comments, we're happy to take any questions that the committee may have for us.
Thank you. Any other comments from anyone else? No? Okay. No worries. So we've got a range of questions and I will throw to my colleagues. So we've got the sunset clause for June 2028. Have you read the audit report from the department?
We read the ANAO
yes,
audit report.
Yes.
Well, I don't know, Paul might have read it in greater detail than me, but I certainly ran over it, skimmed over it.
And what's your views on the findings in that report?
Well, perhaps I might jump in there and say we noted that the Auditor General had some queries, I suppose, about the administration of the scheme by DSS. I thought that some of the language of the Auditor's report was gentle, really, about some of the problems that had been pointed out to the Auditor. But the Auditor General certainly indicated that there were some substantial things that need to be fixed up with administration of the scheme.
Yep. And so with regards to the audit and my question to you, in order to meet the deadlines that the department has set for the NRS, what do you think the strategies need to be in order to meet those deadlines?
Well,
based on the numbers that we've got coming through and a potential surge.
To be frank, I was surprised when I saw the DSS submission to this inquiry, where they said that they will deal with every application by the sunset day, every application that is made to it before 30 June 27. That is when the application made before that date. So I thought, well, how are they going to do that given the backlog that's there? Look, there are some questions, I think, as to how they are going to do it. We certainly hope that it doesn't come at the expense of sound decision making. That was the other aspect that I referred to. When the scheme started, perhaps I go back a step. When the scheme started, by and large, the dioceses were happy to accept what was coming from the independent decision makers in terms of their findings about the likelihood of the applicant for eligibility. But in recent years, the last couple of years, and Helen might have more of a handle on this because she's more at the coalface, the quality of those decisions in some cases is very much astray in our view and in the view of our diocese.
And just to add to that, Dennis, thank you. I think it's not only the quality of the decision making, but the quality of the applications are particularly low, with very little information at all for us to be able to investigate, to give a proper response when there is so little in, some of the applications are 2 lines. It is almost ludicrous to be able to answer those sorts of applications. And it makes us feel that these applications are not, in fact, truthful in some instances, and in some instances phishing.
Does anyone have any further questions online? Dean, Renee or Richard? I can see Dean's got his hand up.
I do. Thank you very much, and thank you for your evidence. Of course, an important part of the claim process is the responsiveness of institutions themselves. Can you detail for the committee what initiatives or reforms you are undertaking or expect to undertake to assist in the processing of that expected surge in applications as we get closer to the scheme closure date? And perhaps you might share with the committee, either in this oral evidence or on notice, some information and data about the responsiveness of the Church to meeting questions and queries around claims, noting, of course, your comment about the difficulty in doing that if a claim is bereft of information.
Well, yes, look, thanks for that question, Senator, and Helen might have some comments on it too. But my understanding is that by and large our diocese respond in providing information within the time limits that they're given. Sometimes if there is a need to trawl into archives of the parish or the diocese, it's going to be difficult to meet that time frame, so we ask for an extension of time. And we get the information in by that time. We as a company keep a close eye on cases where either before the prescribed day for responding or the extended day, which DSS has given, the information has not been provided. But I have to say, there are not many instances where that happens.
Yeah. No, if I may just comment on that. Nearly every one of our dioceses meets their commitments on time. We've got some of our larger dioceses by volume of numbers. One in particular, I won't call them out, but they 100% have met every time frame. They get an extension where it's necessary. If they can't meet the time frame, their tactic is to submit the application through to the scheme and then continue the research and at a later point upload information subsequently into the institutional portal, which the department is quite welcoming of. And as Dennis mentioned, there's only been 2 individual instances where the diocese haven't been able to provide a response and they've gone to the independent decision maker without a diocese response. But in both those cases, the diocese, just as Helen outlined couldn't respond. There's nothing there to respond to, so that maybe not best practice, but they let those ones go through because there's nothing they could add.
Dean, did you want?
Thank you for that. But in your submission, you have a recommendation that calls for additional funding of support services in recognition for the anticipated surge in applications. I'm curious to know what improvements, what enhancements you are putting in place internally, not to meet the established timeframes, but to exceed those timeframes so that the surge in applications can be done as effectively as possible from your particular perspective as a participating institution. So I'm just curious to know, are you expecting or anticipating internally to have different sets of KPIs to ensure that your responsiveness in the scheme is better than the established timeframes in anticipation of the surge that you have recognised will happen in your own submission?
Thanks.
And can I just confirm with regards to this, the time frame now is about 4 to 6 weeks, is that right?
It's not priority, yes.
Yeah. Thank you. Keep going.
So,
Helen.
Senator, we've acknowledged all the way through the scheme that the applications have surged and not surged. So we've responded at every juncture because we have a certain number of applications coming through. We've acknowledged that. We've planned for that. We also, as a company, give out information to all the dioceses to say, this is how we think it's going to happen. This is, we know that we've spent roughly $100 million so far in the scheme. We anticipate another $100 million for the rest of the scheme till 2028. So we know that there is going to be a surge in it. Our staff are extraordinarily, staff around the diocese are extraordinarily capable and making sure, as long as we can get applications that are reasonable and enough to give us information to be able to get the information on our side, we don't see any problem at all in responding to any anticipated surge.
If I may, it's
great. Well, thank you very much for that. So could you just to elaborate on the Church's sort of financial provisioning and financial expectations, as we approach the closure of the scheme? Did I hear you correctly to say that you were anticipating another $100 million worth of claims?
Correct.
Senator, if I may, sorry. Excuse me, Senator, I interrupted you. In response to your question, that the bishops of Australia clearly remain committed to the redress scheme in the parameters that have been set. As Helen has described, at a diocesan level, professional standards officers are in place, or sometimes, depending on situations, rural settings, they might work with another diocese. So in all those commitments, I think the bishops remain committed to the scheme in the terms you described, and have, as Helen has described, the projections made by the company to the bishops are very clear. So I think we're well positioned to anticipate, as Helen has described, to the end of this scheme, the provision we need to make.
Okay, so I'm just keen to understand what is the quantum of that provision at the moment, and how was that quantum calculated? What sort of professional services were engaged to calculate that projection?
The professional services it wasn't an actuary who did that. What we do is plan about the number of cases we're getting, the number of cases that are growing, and we anticipate what that will do in the next 2 to 3 years, and that's how we've got that figure. We're very committed to understand that's a lot of money, as you can understand. It's an enormous amount of money for our diocese, and we're very keen and have given information to dioceses about what is needed and what we are anticipating to come up. you know, I'm a financial administrator in my day job, and I would love that figure to be much lower than that, but we do plan for the worst case scenario because we're committed, as Bishop Gregg said, we're committed to finish off this scheme in a really good way, and we will pay whatever we need to pay to ensure that we've got enough money. The only issue is making sure we're paying for the right redress.
The purpose of my line of questioning goes to something different, and that is that the scheme itself and other interested parties are grappling with issues around the expected size of the surge, concerns around the processing of the surge in claims. So my point goes to what extent have you been engaged with the scheme, engaged with the Department of Social Services to assist them come to an understanding of what the surge might actually look like as a way of developing and preparing for various scheme closure initiatives like some of those that have been canvassed in your submission?
Well, I think in a way, Senator, with all due respect, the way the surge is handled ultimately becomes a matter for the Department of Social Security. I mean, they've given the assurances, and they need, as we urge in our submission, they need to come up with a plan, which we haven't seen to date, about dealing with that surge if there is going to be a surge. Our people are very conscious that if a request for information is not responded to within the time frame, then the independent decision maker is entitled to make a decision without anything from us. So the dioceses do have that hanging over their heads, that we just have to respond.
Thank you very much for that. How does the Church intend to respond, or what are the structures in place to allow just redress to be delivered to survivors of abuse when the scheme closes?
Part of the work of the Commission for Professional Standards and Safeguarding, Senator, was the development of what is referred to as a National Response Protocol. It was established in 2021 and agreed upon by all the Catholic bishops of Australia, including the epicies, as we refer to them. And that is a procedure regarding how receiving a complaint or an allegation is to be treated from a trauma-informed point of view, independent investigation, the pastoral care of people presenting, and a finding of redress eventually. So there is a protocol in place beyond the National Redress Scheme already, which operates. In some provinces, Victoria Province, the 4 dioceses, we have a company called Pathways Victoria, which is also running currently, and some people choose to make their complaint through that independent process as well. So there are mechanisms in place. The National Redress Scheme has provided its framework for many people, but I would be confident that the Church will continue to ensure that anyone with a complaint or an allegation to be made will have that received respectfully and dealt with appropriately through this National Response Protocol, which we've agreed to.
Has the Church made a provision for claims it expects through that process after the closure of the National Redress Scheme?
Helen might be better positioned as a financial administrator.
In terms of what is happening after the redress scheme, it would. I am not aware of any diocese that would be making specific accruals or provisioning for the post-response, the post-redress response. But I can say that every diocese has a large provision for its civil cases and so that would be part of what we'd respond with.
And I think we also say in our submission that the plan that is developed by DSS relating to the wind-up of the scheme will need to make some provision for ongoing help and assistance to those who have found to have been found to be eligible for redress and will need some ongoing help after the scheme finishes to deal with their issues arising from the trauma of the particular incident.
Now I'm aware. Keep one more, Dean. I've got Renee. Yes. Sorry.
Yeah. Just quickly, the issue around the quality of decisions and the consistency of decisions of IDMs has been one that is of keen interest to this committee. And if you're able to sort of furnish the committee with any powerful examples of lack of consistency between claims or seriously unsubstantiated final outcomes, that would be valuable to us. Can you detail for the committee what is the total amount of redress that has been provided by the Church to survivors under the National Redress Scheme since its commencement?
I think, Senator, we'd have some reluctance in this before this committee to disclose that, given the protected information provisions of the Act. We can give sort of we can talk about percentages of cases that are determined and percentages of our cases that remain undetermined, but I must say I would have some reluctance about disclosing that particular figure here, given the fact that the protected information provisions protect not only applicants but also protect the institutions.
So I think so just go back to your first response. Yeah, that would be very, very valuable. Just some data around the number of applications that have been resolved, those that are still outstanding. That would be valuable. The question about what is the quantum of funds that the Church has provided to the National Redress Scheme, to survivors of the National Redress Scheme at a macro level, not an individual level. Perhaps you can take that on notice.
Yes.
And if there is some resistance to do that, then we can discuss various ways that information may or may not be available to the committee by way of confidential submissions. So if you wouldn't mind just taking that on notice,
we will take that one on notice and see what we can do.
Thank you very much, Chair. Thank you.
Thanks, Dean. Just on that amount, you did mention, though, you've 100 million and an additional 100.
Just to be clear about that for clarity purposes, this is part of the diocese. This is not the whole of the Australian Catholic Church. So we represent 28 dioceses and eparchies, 35. None of the religious orders are included with us. So we don't have the information for the wider Catholic Church.
Right. Okay. So it's just for the 35 that you represent.
The diocese, geographical dioceses of Australia.
Yep.
Renee, you've got your hand up. Would you like to ask your question or questions?
Thank you so much. My question, I think in the testimony that we've heard so far in these hearings is that there has been some challenges with making sure that awareness is raised in certain parts of the community, in particular, people with disabilities, languages other than English, First Nations, regional and remote people, people who have poor literacy levels or challenging mental health, even incarceration. So all of these types of communities. With the scheme closing date fast approaching, I'm just keen to understand the scope of any communications that you've done out to raise awareness about the scheme within your communities and the communities that you've worked within, and how that has been to date, and with the scheme's impending closing date, whether you have any intention to do that differently or change how you work with those communities, just what your thinking is about how to ensure that people are aware of the scheme's existence and their rights under it.
Member, we really see that as a function for the Department of Social Services to publicise the scheme, not so much us, but well, maybe that's all I need to say, really. Yeah, we just, in terms of people, disadvantaged people, people with disabilities and what have you, we just treat each application that we're required to respond to on its merits and leave it at that. And the question as to where that will go once the independent decision maker receives that information is really a matter, I think, for the scheme itself.
Thank you. And so just to clarify, so with the 35 dioceses that you are responsible for, there wasn't a kind of a communication plan in the Catholic newsletters or information going out to parishioners about the scheme when it started?
Paul, do you want to talk about what goes out from you to the diocese?
Yes, certainly. Dennis is referring to a document, ACRL issues on a quarterly basis. It probably goes back to the earlier questions regarding work towards the potential peak in applications. But it's more of a strategic letter to the diocese. So we outline what we've received nationally, because they only see the number of applications at their own diocese level. It's not a community-wide newsletter, so it's just internal use. We tell the diocese where the peaks are, where the pressure points are, and what they're likely to see in the future for planning purposes. As I say, it's not an external document. But as far as I understand, as reinforcing what Dennis said, the diocese don't do any advertising per se. That's not to say they don't shy back from it. I'm sure where people come to them, as we said before, people may choose to come to diocese directly to seek some sort of redress. The diocese the safeguarding people would then advise them on the best path for them, for their situation.
I may add, Chair, as well, every diocese would have its own website. On every website there would be a tile for professional standards or complaint management, and I'm sure, I can't guarantee, but within that portal the different ways people may wish to progress a complaint would be listed, and this national redress is surely one of them, as Paul's referring. If someone from our staff groups was speaking to someone, they would certainly put that before them.
I guess it...
We would certainly, as we say in our submission, we would support extra funding to Know More, which is the sort of expert body in this area with assisting applicants, and we'd welcome people who need assistance with their applications using Know More to provide to assist with the application, because I think our experience is if applications come in with that sort of help, they're a bit easier to deal with.
Yep, definitely.
Yeah, so I think just in summary, it's probably fair to say that the diocese that you're responsible for, the approach has been a responsive, reactive one to applications rather than, communicating the avenues out to your communities.
I think that's probably true. Yeah.
Okay,
So
thank you so much.
Just on Renee's question, so that in your experience with the scheme, what do you think needs to be done to help promote it so that people are aware of it? Have you got any suggestions? You may or may not.
Well, I think there needs to be extra funding for Know More. They went through a stage there where they were crying really poor. I think the government did provide some extra funding for them, but given the surge in cases that is probably coming, I don't know, then there certainly needs to be sufficient funding to enable No More to assist people who may be thinking of making an application in these last years of the scheme.
So I just want to go backwards a little bit. One of the questions we've had of other people we've spoken with is around bottlenecks in the processing of applications. And it sounds like you've got a thorough process or working quite well with the 4 to 6 week and asking for extension. But I'm interested to know, what do you think creates bottlenecks in the application process?
Well, from a reactive perspective, we react to what we get. So we
from the applicant,
from the portal, which goes to ACRL, and then ACRL in the portal goes out to each diocese. So each application is given to a diocese to deal with, to send in the RFI. So the bottlenecks is that, we may have, and I know because I have to deal with each one of them in my diocese, is that we might have one a week for a few weeks, and all of a sudden we'll get 6 or 7 in a week, 5 or 6 in a week. So the bottleneck isn't from our perspective, it's from when we receive them, because we respond. And it's very hard to plan in terms of staffing. We don't have that. We just have to respond, whatever we get. So we respond in a way, there's issues about getting information from schools when there's school holidays. That's one of our big issues. So if the RFI comes in during the school holidays and we know there's nobody at the school to be able to get records, we'll ask for an extension, and that's what we'll do virtually every time. So we respond in a time critical way, because we know that we can't sit on these ones. We've got to keep moving through them because we don't know what's coming up next. So that's our problem to deal with, and we do. But I suppose having a better response from the department, giving them in a sort of a more, well, I don't know how you do that, because we get a number of them. It could be all based in one diocese. It could be based in a whole range of dioceses. So it's very difficult. But we can see the bottlenecks appear when they come through to us.
But the real bottleneck does appear to be in the department. I mean, just looking again in talking percentage terms, we've had 52% of applications finalised. That's right across the applications being made to our diocese. But 41% of applications that have been made to us and that we've responded to with the requested information remain undetermined. They're sitting there somewhere in the department waiting for a decision. That's really where the key bottleneck is.
So what do you think that potential, what's that demonstrating to you, do you think?
There's a few issues there. One is that once we do the RFI, it goes back to the independent decision maker, and I'm not sure what their bottleneck is. I know there's a certain number of IDMs, and I don't know whether they're experiencing bottlenecks and trying to get the information, make a decision. But there's also the ability for the applicant to have 6 months to respond to that. And we know that some of them are taking much longer than that, and I don't know why.
So, sorry, I'm getting into the weeds a little bit here, but so they've got...
We're happy with weeds.
So the IDM have 6 months to get back to you?
No, sorry. Once the IDM makes the decision and we're aware of that decision, we get told as well, the applicant gets the decision, they have 6 months to agree or not agree to it.
The applicant.
The applicant. But we know that some of the applicants are taking longer than that. Much longer in some cases. Okay. So that's why that Dennis mentioned, the 41% of applicants sitting there, we're all just waiting on that, trying to understand where... And of course that's difficult for our planning in terms of money, because we know that the IDM will say that person is eligible. We'll have a relatively good idea of what that money will be. But we don't know when that hits because of the time it takes.
With the time being with the applicant.
With the applicant.
With the applicant, whether to accept the offer of redress that's made.
Yeah. Okay. Dean, did you have any other questions? No. Okay. You mentioned the Island Residential Institutions Redress Board and lessons from those programs. Do you have anything specific that you would like to share with us about that specific scheme and what they're doing?
Well, I think the answer to that is no, but we understood that they managed to wrap that scheme up on time, or if not almost on time, despite a surge of cases at the end, which is sort of natural, I suppose, for schemes of this kind. We've said to the Department of Social Services, you need to be looking at some of these other international examples. And the Scottish scheme is also quite relevant because it only runs for 5 years. It's still going, but they obviously have ways of dealing with things much quicker than Department of Social Services is doing in its management of the National Redress Scheme.
Now, I know we've got 5 more minutes and there's a couple of other questions. So the stat decks, you've suggested in your notes that you think that they should be reintroduced.
Well, look, I know it's a sort of a double-edged sword, because that will take, there's sort of time issues involved in that. But we have to say that the stat deck was there at the start of the scheme. We had much better applications that we could deal with much more satisfactorily when we had a statutory declaration. Now, I know with COVID and what have you, that it was decided to do without stat decks, but we think that the rigour of providing a stat deck is a way of ensuring that you've got an application that you can deal with more easily.
And do you think that potentially is a fraud deterrence mechanism? Because you've mentioned.
Well, I think it is. Yeah, I think it is. They've got to tell their story to before a qualified witness, and not that the qualified witness, of course, goes into the story, but just the discipline of doing that, I think, helps.
So, 2 more questions. We've got the 8-year review that's due to commence this year. Have you got any thoughts on what they should be considering or focusing?
Not really. My understanding is that that's sort of going to be handled internally between the governments, effectively. But I'm assuming that's going to be dealing with these issues of, how they handle the backlog and the steps for doing that.
If you, what are the top 3 things that we need to be focusing on going forward, based on your submission experience of the scheme?
Well, the backlog of cases.
Yeah.
What are they going to do to get rid of these numbers of cases that have been determined by the independent decision makers, but are still sitting there? I think the second, so that's probably one of the 3. Another one is the quality of decision making. Now, again, a bit of a quandary there, because if you're going to be processing a lot of cases, the danger is they're going to be low quality decisions, but that mustn't be allowed to happen. There needs to be proper guidance for independent decision makers in how to address the reasonable likelihood test, and we're not satisfied that is satisfactorily being done at the moment. Does anyone have a third suggestion?
Well, I just think the strategic timeline now for the department to really, through the review, to say, well, the redress scheme is to finish. How are we going to structure our advertising campaign? All these things that we've raised, hopefully to really support the DSS moving through these cases.
We have said in relation to advertising, and we have no objection to the advertising, but there does need to be safeguards put in place against claim farming, because there has been some documented cases, as this committee would be aware, where claim farming has occurred, and of course that's highly undesirable and indeed has been legislated against in some states, but not all, I think.
Any other questions from my colleagues? Renee, Richard, Dean?
Yeah, just quickly. Are you actually proposing to change the evidentiary standard, or is your submission that the reasonably likelihood test is just not being applied correctly? It was a bit unclear because in your submission you also mentioned the balance of probabilities that's used in civil cases.
It's the latter. We're saying that it's not being properly applied.
Right. And maybe this might be something for to take on notice, but it's a bit hard for us to assess that unless you've got some specific examples that we can sort of see, is that happening systemically or is there just some particular isolated cases?
I suppose when you have a case where the claim is about a priest having done something at some stage, and our records show that priest was not in the parish concerned until 8 years after the applicant said the incident occurred. It's those sort of frustrating things, really, where the facts provide absolutely no support and indeed contradict what the applicant is saying. I think independent decision makers need to be a bit more rigorous about dealing with some of those facts that are put before them from the diocese.
Right, and is that a more recent trend, or has that been across the whole period of the scheme?
Well, we think it's a more recent trend, really.
Last 2 years.
The last couple of years, we're seeing more of those sorts of problems. Initially, when the whole thing kicked off, admittedly, there weren't a huge amount of cases, and for the first couple of years, but it did seem to be a higher quality process than we're now seeing.
So just on that, we are aware they've appointed some more IDMs more recently in the last 6 to 9 months, and so so I'll be interested, because I think you've just said 2 years. I'd be interested to see what the impact of that would be going forward. But that's
Interesting point.
I think the other issue too, just quickly, is there is a stacking mentality that's going on. If one case is given eligibility when we think that the facts are dubious at best, then that plays on to another case and another case that relies on those earlier facts, which we think are dubious. So that stacking, we're seeing stacking of claims that come from various family members or members of different families that we're knowing that is doing that. So that's a concern for us.
right. No other questions? Any other comments? No?
No, thank you for listening to us today.
Well, thank you for submitting your submission. Yes.
Well, we hope it's helpful.
Yes, very helpful. So I just want to thank you for your attendance today. You will be sent a copy of the transcript of your evidence, and we'll have an opportunity to request corrections to the transcription. Sorry, my phone, I need to turn that off after you leave. Please send your responses to any questions taken on notice during this hearing to the Secretariat by the time the Secretariat will advise, which is 2 weeks from today, I think, Eva?
2 weeks from when the transcript.
Oh, true. Right. Beautiful. Beautiful. All right. Thank you very much.
Thank you. Thank you, everyone.
And we'll just suspend the meeting briefly, the hearing briefly. No, yeah, we are now. Well, good morning and welcome. I will just read out the introduction, and first of all, I will just get my colleagues to introduce themselves, starting with you, Dean, Senator Smith.
Good morning. My name is Senator Dean Smith, a Liberal Senator from Western Australia and the Deputy Chair of this committee.
Renee, would you like to go next?
Yes, hello, I'm Renee Coffey. I'm the member for Griffith in Brisbane.
And Richard.
Hi there, Senator Richard Dowling, Senator for Tasmania.
And I'm Jodie Ballier, the federal member for Dunkley in Victoria and the chair. I now welcome representatives from the Anglican Church of Australia to give evidence today. For the benefit of Hansard, would you please state your full name and the capacity in which you appear before the committee?
Thank you. Joe Thorpe. I'm the Chair of the Board of Anglican Representative National Redress Scheme Limited.
Tracy Longfield. I'm the Company Secretary of the Anglican Representative National Redress Scheme Limited.
Thank you both. This hearing is a legal proceeding of the Parliament and it has the same standing as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Do you wish to make an opening statement?
If I could
Yes,
please,
absolutely.
Chair. Thank you. From the outset, can I reiterate our acknowledgement with deep regret and repentance the past failings of the Anglican Church and its members, and on behalf of the whole Church, we apologise to those who have been harmed by sexual abuse perpetrated by people holding positions of power and trust in the Church. It's worth for a moment, particularly given the previous witnesses here, to remind the committee of the complexity of our constitutional and operating arrangements. We're 23 independent dioceses in communion with each other. The primate is the titular head of the bishops, a first among equals, but has no power to compel. The legislation adopted by a General Synod only applies in a diocese if it's adopted by that diocese. Then within the various dioceses, some have schools, Anglicares and other agencies under the direct ownership and control of the diocese, and others where there is no constitutional control or commercial ownership whatsoever. So whilst this makes for an energetic freedom of operation within our instruments of communion, it does not make for simple administrative control and execution, with the General Synod office, where Tracy works, being more akin to a secretariat than a head office. So given that, it was a remarkable achievement of our Standing Committee to establish the Anglican Representative National Redress Scheme Limited to represent and support Anglican institutions in their relationship with the scheme, and at present all 23 dioceses, 62 agencies and 74 schools are members. Membership provides a guarantee in the form of joint and several liability, ensuring that the financial difficulties of any one member would not ultimately impact on the payment of redress to a scheme applicant. That explains why I'm here as the chair of the company representing the Anglican Church of Australia alongside Tracy, and it also explains in part why our submission consisted of several individual inputs rather than a coherent whole, which I apologise for if that was unhelpful. There's a number of themes though within those which, if the committee is happy for me to spend a couple of minutes, I can just take you through what I think are the kind of key themes rather than all the individuals, if you're happy with that, Chair.
Yes, absolutely.
Thank you very much. So first of all, in terms of operational timeline, we do not support extending the timeline for the acceptance of applications to the scheme. The 10-year life was, in our view, integral to the policy balance between survivor access to redress on the one hand and institutional certainty on the other. In our view, the scheme was and is well publicised, the opportunities to apply ample. We are concerned, however, that the scheme remain active long enough to appropriately process applications and responses, make determinations and pay redress to eligible claimants. We think it's important in the run-off attention be made to maintaining survivor support services, particularly counselling and legal advice, as part of the architecture of social services supports maintained by government at state and federal level. Within our organisation, we are already actively encouraging our members to ensure they have alternative redress pathways with adequate supports for applicants in place prior to June 2027, and we believe all institutions should be encouraged to do the same. In terms of case management, we understand somewhere approaching 60% of redress applications remain undetermined. In our group, a little over 32% are undetermined. We understand the average processing time exceeds 16 months. We would support the establishment of transparent reporting and communication protocols to keep applicants and institutions informed of claims progress. In addition, the addition of reasons and determinations was anticipated to be helpful to build trust and integrity into a system with low evidentiary bar and lack of appeal processes. Regrettably, in our view, the reports in their current form do not really improve institutional understanding. Your attention is drawn in our submission to the particular issues being experienced with the interface of the National Redress Scheme with the PIPA claims in respect of North Queensland. During the establishment of the scheme, it was stated that the scheme aims to ensure institutional viability rather than bankrupt them. However, the weight of claims on North Queensland has caused that diocese to go into receivership. While survivors will continue to receive redress through the Anglican Church's Anglican Representative Limited, doing so is having a material effect on the provision of ministry by our institution. It's the source of considerable pain for our community, which is perhaps another form of institutional abuse. Following the changes in 2024 that expanded access, we're seeing a material increase in applications, and over 25% of all applications in the Anglican system have been received just in the last 12 months. It does appear that on average the quality and adequacy of the information provided is decreasing, the percentage of non-liable determinations is increasing, and we also understand the percentage of applications becoming institutional RFIs is decreasing. There are ample concerns in our view for the potential for fraudulent or exaggerated claims, and regrettably there is a significant volume of information available in the public sphere and an elevated risk of claims being able to be constructed with AI engines, particularly as evidentiary thresholds remain low. We're encouraged the Department has implemented fraud controls and trust they'll be provided with the funding and tools to keep pace with this rapidly emerging area. This is another reason why we do not support an extension of the application beyond 2027. We remain deeply troubled by the very low number of applicants taking up the opportunity for a direct personal response. Having been personally involved in the provision of such responses, both through the National Redress Scheme and in civil proceedings, I can attest to the incredible power of being heard, believed and receiving an apology. The limitation on institutional capacity to use the information in RFIs remains a concern. We trust the agencies use the relevant information to make appropriate police and car reports, as we are unable to act on the information provided for any other purpose other than to respond to the RFI. Therefore, we're unable to institute our own professional standards or disciplinary proceedings. This means there is all likelihood that a perpetrator remains in their role unless there is reporting via some other mechanism. We would like to have seen the scheme clarify and codify information sharing protocols for mandatory reporting and disciplinary proceedings. So at this juncture, we've got nothing to add to our earlier comments around lengthy timelines between application and outcome, lack of protocols for reporting application progress for the applicant or the responding institution, robustness and detail around reasons for decision, potential for fraud, lack of appeal rights. None of these issues go to the particularities about the end date for the scheme, except to say that if the Parliament were to consider extending the application window, these matters would require heightened examination so that institutional trust in the integrity of the scheme could be maintained. That's the end of my statement, Chair. Thank you.
Thank you. Appreciate all that you've got in there. I suppose my first question to both of you is the ANAO delivered an audit earlier this year, late last year. It's all merging into one. Did you have an opportunity to review that and the feedback that came from that audit?
I've read the summary of the report. I'm afraid I haven't read the complete report.
Yeah. And what did you think about the findings in that report?
We weren't surprised. I mean, they go to some of the issues that I've raised around transparency and processing times and reporting. And I think we've seen some improvement over the last 12 months in terms of reasons for decision.
We have, and we're also now, the Department of Social Service who administers this, they're now actually actively looking at cases they believe might be fraudulent. So instead of RFIs being sent direct to us, often they'll now go back to the claimant and try to prove their validity before we receive them. So we appreciate that the DSS are definitely, trying everything they possibly can, and like us, they've been deluged with a whole lot more claims than I think they ever anticipated.
So the question I have is around the numbers and the potential surge in numbers as we come towards the end date, and the capacity for organisations to actually support those claims. What do you think as an organisation needs to be considered in order to you're advocating for the end date to be 2028?
No. So sorry, to be clear, I think the scheme finishes taking applications in June 2027,
yep.
and we don't see any justification presently for an extension to that.
Right,
the administrative
okay.
arrangements finish at the end of 2028. We're saying we think there needs to be adequate resourcing and probably more time to enable all of those claims to be properly dealt with by the department and the responding institutions. I think survivors deserve the right to have their claims dealt with properly.
So an end date for receiving applications by June 2027 with an extension of the assessment.
If the department found that was necessary.
And what do you think would help organisations such as yourself in the actual process to support the review and assessment?
I think I know it's almost impossible, but if you could actually eliminate all of the false claims, that would be amazing, because it really does seem, just from the increase in non-liable determinations, that seems to be an issue. And in the data sheets, there's discussions about fraud now, so that's something that DSS is quite clear about. So if you could do that would eliminate some of the problem for our people. Because the 23 dioceses and the participating organisations are all very different. So we have some organisations like the Sydney Diocese that is quite large, a lot of staff, have a lot of people dealing with this. And they can get more staff quite easily. But places like the North Queensland, they're this tiny office, they actually don't have a registrar to run the place, so there's no real administrative assistance there, because in their attempt to stay afloat, the first thing they've done is cut their administration staff. Yep. So they're actually being completely pummeled, and there's a couple of sites that are getting a lot of traction with them. As to
sites as in a diocese?
As in a particular orphanage. So,
yeah.
so there's a lot of activity for that particular institution. So they have less resources. So you've got a 2 to 4 week window, and unfortunately at the beginning of the scheme, some of the dioceses felt that there weren't as many applications. Some of the dioceses felt that it was the right thing to not really do much in the way of refuting it. They felt that it was, not respectful to the claimants. So there have been some claims go through that, if received now, probably would have been pushed back a bit harder on that sort of thing. But so they're trying to now deal with a lot of redress claims, and they really don't have the staffing for it. So that is an issue. How you fix that, I'm not quite sure, other than another diocese coming in to pick it up. But there's an issue with that because of privacy as well. So that would be the main thing that could assist in that.
We found the scheme to be very helpful in granting extensions.
They have been excellent at doing that.
But we're doing that on a case-by-case basis. So sometimes the response window is pretty tight, particularly if there's a high volume. I think one of the other issues is, there's a lot of redacting, which sometimes makes it hard to chase down details in the request for information. And then I think in my comments I've made the comment, and it's in some of the individual submissions as well, that of late we're seeing somewhat less detail. So, which gives rise to coming in the RFI, the request for information, which gives rise to concerns about is this a claim farm? Has this been kind of is this fraudulent? What that just kind of gives us reduces our confidence that what we're dealing with is a genuine claim with lots of information. And so it makes it very difficult for the institution to respond, because there often is, there's nothing known, and so you're wrestling with smoke a bit. So I would just encourage the department to do what it is already doing, which is to run the quality assurance over the request for information.
So just on the department and what they could be doing more of, What would you recommend there? Because
they probably need more staff, I think, is probably the first thing, because I think the problem for them was that it started out, there was an estimate of, I don't know, say 60,000 for the entire scheme, and it looked as if that wasn't going to go. So it actually looked as if the scheme was going to have a lot less than that. And then all of a sudden, there's just absolute deluge. So I imagine they've had trouble staffing adequately. So more staffing, probably more looking at the beginning, rather than like actually looking into the fraud and the doing the callbacks to people in advance of us getting them.
So a bit more attention to detail in the front part of the application process.
Yes. And it would also be helpful with the determinations if there could actually be a reason why this particular determination was found liable, but the next one that seemed really similar came in as non-liable. So there seems a little bit of inconsistency with that, which I appreciate, is you've got different determiners looking at different cases. So, so if dioceses and participating organisations could have that information, it would allow them to better respond to the RFIs.
I think it's the case management of working with the applicant to increase the quality and detail of the application would then assist institutions to respond.
Renee and Richard, I think, Dean, Dean, did you have a question? I don't think you're off mic, so I thought you might.
I do. I was just hoping you might be able to explain in a little bit more detail your comments around the personal apology.
Yeah, I think so the applicant is able to tick a box when the decision is made to say, I'd like to receive a direct personal response, okay? And I don't have the numbers to hand, you might, of the percentage of people who tick that box. But then the applicant has to make contact with the institution. The institution is unable to reach out to the applicant. We don't have their contact details. It would be inappropriate for a whole range of reasons for the institution to reach out. So all of us have been encouraged to establish a direct personal response facilitator. Most of our institutions have. We try and publicise who that person is to make it more approachable for the applicant to come to the institution and seek the personal response. The numbers who come to the institution are incredibly low. And I think it's a matter of great regret that full so there is redress in the sense that I was heard, it was recognised, I received a payment, so there is acknowledgement from the scheme and ergo the institution that the abuse happened and that there's some responsibility. But there's a big missing link in my view, which is the actual apology from the institution to the person. And I've been involved in a number of them, either with the Archbishop or providing it myself in civil proceedings, where at the beginning of a civil proceedings you might be in conference, in a settlement conference, and the counterparty will say, I will always offer, does the applicant want to be heard and receive an apology? And sometimes they'll say yes, and we will do that even before we start the negotiation, right, in the settlement. And I will always give an apology and say it's not your fault, what happened wasn't your fault, you had a right to trust, da-da-da-da. There is a kind of bit of a script that we've worked out with our survivor advocate that works. And I can tell you that the impact on the person receiving the apology, it's visceral. You can see a weight go off their shoulders. There's often tears. In our context, I'll say, are you still a Christian? Do you still believe in God? Yes, I am. And then we'll add, well, God was with you. God didn't abandon you. You did nothing wrong. God still loves you. It's an incredibly powerful thing. And I think it's a great regret in my view, and I know it's a shared view, that so many survivors don't get that moment.
Well, my observation would be that it is such a critical human element in the whole healing process. How do you explain my words, I mean loose words, but how do you explain the lack of interest in in seeking that direct personal response?
I don't know. We were a participant in a trial to try and increase the number of respondents. So the department did run a trial. They did do some more case management. They did encourage connection, and I don't think it moved the dial. So I think one reason may well be that there was so much damage that there's a loss of trust, and coming back to the institution is not something that people are ready to do. That the mere fact of having to tell their story again to the case manager to record it is a burden. Some people would not want to go into an environment where they have to do that again. It's a burden. It's difficult. I just wish that somehow or another a facilitation could occur so the opportunity could happen, because it is very powerful. But I totally understand the structures that are in place and why it is entirely survivor-driven, as it should be.
So do you have an observation about the role that support services are or are not playing in terms of facilitating these direct personal responses? And I understand your point completely. It's such an integral part. I'm not a psychologist, but such an integral part in assisting someone come to that, go through that healing journey.
I'm not really able to comment because we are separated from the case management of the applicant. I really don't have any insights that I can add.
Because we don't even know if somebody takes up the support payment. In fact, there's some confusion about some states. Apparently, the money's held until somebody puts in a claim to have the support. Other people are given the payment to go and get their own support. So there's not. We don't have any data whatsoever about who's even taking up the support.
That's the counselling.
The counselling. So we just see that we've paid, the institutions have paid a particular amount, and we're not sure. We have asked what is happening with the money that hasn't been taken up and what the plan is, but DSS haven't been able to tell us yet.
It's a very, very powerful point. Thank you very much for that.
So one of the questions that we have is around the marketing and communication, or the awareness raising of the scheme. Do the Anglican churches or organisation promote the NRS, and how do you do that? And what do you think needs to be done to meet or attract the harder to reach target groups?
So again, each of the individual dioceses or schools, again, because we're not a kind of centralised control show, but I can say in general, all of the dioceses have something on their website. Many of them, it's quite visible, seeking redress, or, have you suffered abuse, or some other question like that on the front page that leads people quickly through to here's your options and National Redress Scheme. It's in our interest to promote National Redress Scheme, obviously above civil claims for financial reasons, and for ease of access for the survivor. So I think all of us have done it. A number of us have, in Adelaide we have employed a survivor advocate. A number of dioceses have a similar kind of a role. They might call it something different, but those people are engaging with survivor communities, and there are pretty well established networks across the country, as I've discovered as we've got deeper into this, where word can kind of get out. So I think individual dioceses and schools have done a pretty good job. In terms of the scheme, I'm not clear about what the publicity that the scheme has done recently into those communities. It's not clear to me, but I'm probably not in those channels. So, but I think given that we're now nearly a year away from close, it probably wouldn't hurt to have a bit of a burst of publicity, just to, and there are considerable networks that the department would know about, rather than doing a.
So are your survivor advocates that reach out and promote the scheme, are they paid? Are they volunteers?
So in the Adelaide example, we employ them, but they don't work out of our office. They don't have an office phone number. We just say they're independently employed and engaged. It's a highly experienced person who's come out of sexual support services and sexual assault services and university services with a considerable network. And in our case, she is incredibly well networked across all of those agencies.
Yeah.
And I think the same is true in some other places, but I can't say...
The smaller dioceses and organisations wouldn't...
That would be true of the metropolitans, not of the regionals.
So it's not a consistent approach, it's those
No, it's
that
diocese by
technically...
diocese.
Yeah, no worries. Yeah. Renee and Richard, do you have questions?
My question's been answered. Thank you so much.
Look, I think partly also been answered, and you've indicated this morning that additional resourcing would improve some of the application quality and processing, but your submission also sort of pointed to some structural issues about backlogs, inconsistent decision-making, longer timeframes. I'm trying to understand, do you still think there's actual design flaws within the scheme and how applications are being processed that simply throwing more resources wouldn't fix?
I don't think so.
No, I think I think if you the timeline for us would shorten obviously if the fraudulent and less the cases that have actually less information in them were removed or came to us at a later stage. But as to how that probably wouldn't impact the total length of time for any claim from the time it was lodged. So I think more staff would be the...
Can you
resourcing is the primary issue, you think?
I think so.
Yeah.
Okay. And just in terms of, you've also raised concerns about declining information quality, potentially lower evidentiary thresholds and potentially more unsubstantiated claims. Do you think, is this something you're suggesting has changed more recently within the scheme, or it's always been the case?
More recently, so there was an opening up to vulnerable cohorts. I think we're seeing some patterns that might suggest there's some claim farming, might suggest some networking. It might suggest that there is a lot of publicly available information now from which a claim can be constructed. And all of those things go to risk in a low evidentiary threshold environment. So hence the need for really good case management by the department of the application in the initial stages.
I think that my dealings with the Department of Social Services back in the end of 2023, it was flagged that there were definitely some fraudulent cases, and there was some, the DSS were using AI to try and identify them. But it's definitely gone, like it seems to have exploded just over time with more things in the media, and yes, it's definitely increasing.
Can you just give us a bit of a summary of what a fraudulent claim might look like?
Often it's copied, like it'll be very similar to another case. And one of the issues with the DSS is that if something's considered to be probable, that will be based on previous cases. So if you've got similar data, and then it might be deemed to be determined liable, just because every other time that's come up, it really was liable. So it's tricky, but I know that they're looking at IP addresses to see where things are coming from, and they are looking at a lot of different things, but it's like all cybersecurity, it's on everybody's mind, and it's really hard to combat.
So there are some well-known groups. So in our case, the Church of England Boys Society was like akin to the Boy Scouts. Mm-hmm. And there are some well-known perpetrators amongst that. In that, there was a pedophile ring operating within that. It was not, it wasn't priests. It was people who had attached themselves to it. Pedophile ring running. All those names and locations are well known, and it's not hard to construct a case to say I was one of those boys, right? And so then you're relying on the institution. Did you have records? of that person attending or not attending, and we can respond and say, well, we have lots of records of people who attended, we have no record of that person whatsoever, but because all of the other facts stack up, there's likely to be a finding of liability, which wouldn't even see the light of day if you went near a courtroom.
Okay.
And that's true for some of the homes and other, missions.
And where else are you seeing some of these? You said, there's new cohorts that you're seeing more fraudulent claims come from. Have you got any?
We also had one. We had a case where the church itself was investigating a bishop, and there was never any suggestion of sexual misconduct from him, but he was accused of covering up. So the minute that his case hit the papers, suddenly there were three RFIs with his name on them. So the first one came back as liable, and then the next two come back as non-liable. But that was something that because it had hit the papers. Suddenly that was one of the. Well, we assume it was fraudulent because never in all the years have been any indication that he was a perpetrator as such.
I just wanted to drill into the mandatory reporting you spoke to in your submission about the confidentiality versus the protection piece. There's a bit of a disconnect there. Have you got any suggestions on what could be done to address that?
We have had submissions to the DSS with this before, and they have made some changes, but we have a national register that you need to have secure access to, and we wanted to be able to put anybody that was found to be a perpetrator on that, but we weren't allowed to. So basically we were told that the only way that we could share that information was if it was a police investigation or...
So how long ago was this request submitted for the department?
It came to Parliament. It was the end of 2023 maybe, and so 2024.
Some time back.
Yep.
Yes.
Would you recommend that be reviewed?
Well, we would like it reviewed.
Do you have any comments or questions on that one, Dean? No.
No.
Okay. Any other questions from my colleagues?
No, thanks.
My last question for you is really, what would you recommend to us are the top 3 things you think we need to really lean into as we're preparing this inquiry, these report?
Well, we can swap notes, but I think we've made it pretty clear that case management with applications on the way in to improve the quality of information and alongside the fraud control that is happening, that those two things together I think are really critical, and they need to be adequately staffed and with proper kind of oversight so that there's consistency, because we do see quite a variation. I think that's a really important one. I think it's in the interests of survivors that they have the opportunity to have their application heard, processed properly, not rushed, and proper findings found. And so if the scheme needs to be extended beyond 2028, the administrative part of the scheme, then that consideration should be given to that. Is there a third?
We haven't really talked about it, but at the moment claimants have a right for review, but the institution doesn't. So we've had a couple of instances where there's clearly been a mistake in the even in the institution, but we haven't been able to go back because it's already been granted. So there's no review process for the institutions if the determination is seen to be incorrect.
Yeah. So the reasons for decision process that was introduced, I reckon you could get AI to do it. It's that useless, right? So it's very formulaic. it actually reflects the criteria of the scheme. So it's like tick, 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 that's the reason for decision, rather than a more comprehensive, properly described reason for decision. And so with that lack of reason and lack of appeal rights, it undermines integrity.
And an example of that is people that were actually trying to get the information to reply to the RFI. They were going through their records, and a few of our organisations were putting no data found, which in their mind was they'd looked, there was no data found. The DSS looked at that and went, oh, we hadn't bothered to look. So we did have a meeting with them, and we were talking about things that came to light that, you know, if you think they're very keen for us to call out fraud, they're very keen for us to say, okay, we looked at all of these things, we have very comprehensive records, and we didn't find something. So we've been trying to educate our institutions about responding clearer to these claims. So had we known that in the beginning, there might have been less claims found liable. And we're not suggesting that we don't want legitimate claims found liable, but when we've got the Diocese of North Queensland that's bankrupt, they were almost, if we weren't there to bail them out, the actual legitimate claimants wouldn't have been able to receive anything at all. So, you know, we're mindful that we're happy to pay, well, not happy because we'd rather there was none, but, you know, we're very happy to pay if it's a legitimate claim, but we don't want funds going to people that are not legitimate.
Yeah, there's a particular issue in North Queensland in the relationship between the state and the church, where under the PIPA claims, which I made comment about in my introduction, and it's in the submission, without going into taking up the committee's time in too much detail, in the PIPA claim arrangement, the church was really there working alongside government, on behalf of government, delivering services, and government in Queensland was being held liable for most of the PIPA claims. Under the National Redress Scheme, we're being held 100% responsible for them because it was our boots on the ground. But actually, we were kind of acting on behalf of, and so there doesn't appear to be any kind of joint liability, and we think it's swung far too far. But we can't push back on it. We don't have the appeal rights. We don't have the capacity to say this isn't fair. It's just the decision is the decision. And, you know, this is in relation to Aboriginal missions right up in far north Queensland, where the church was just in there trying to do the right thing, working with government back in the day, and now we're being held 100% responsible for things that, in our view, we're not 100% responsible for, and it's caused an enormous amount of damage. It's a good thing that the survivors are being recognised and redress is happening, but there's a kind of an internal issue there that we just have no capacity to influence a different outcome. Yeah.
If we've got no more questions, we'll finish up. I'll just read out my closing statement. I want to thank you both for your attendance today, and you will be sent a copy of the transcript of your evidence, and will have an opportunity to request corrections to transcription errors. Please send your responses to any questions taken on notice during this hearing to the Secretariat by the time that the Secretariat will advise. And I'm happy to say this meeting's closed, and thank you very much for your time and your submission today and all the work you do.
Excellent.
Yeah.
Thank you, Chair.
Thank you.
And
Suspend the proceedings until 11. Everybody, we're going to kick off. I'm Jodie Ballier, the Federal Member for Dunkley and the Chair of the National Redress Committee. If my colleagues Renee and Dean would like to introduce themselves.
Yes, absolutely. I've said hello to Leonie informally just while we were waiting. I'm Renee Coffey. I'm the Federal Member for Griffith in Brisbane.
Thanks, Renee. Dean.
Good morning. My name is Dean Smith and I'm a Liberal Senator for Western Australia and the Deputy Chair of the Committee.
And I'm Jodie Ballier, the Federal Member for Dunkley, which is in Victoria, and the Chair of the Committee. I'd like to thank you all for submitting your submission and also for being in attendance today. I now welcome representatives from Care Leavers Australasia Network, CLAN, to give evidence today. For the benefit of Hansard, would you please state your full name and the capacity in which you appear before the committee?
Thank you, Chair. My name is Leonie Mary Schutte and I'm the co-founder and CEO of CLAN.
Thanks, Leonie.
Hi, I'm Natalie Wallace. I'm the head counsellor at CLAN.
Thanks, Natalie. For your benefit, this hearing is a legal proceeding of the Parliament and it has the same standing orders as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Do you wish to make an opening statement today before we start the discussion?
Yes, please, Chair.
Thanks.
I'd just like to... Sorry.
That's all right, Leonie.
Okay. At every CLAN event, social or launches of Australian Orphanage Museum, officers of CLAN, we always have a minute's silence. I don't wish to take up valuable time for a minute's silence, but I would like to read the card, the postcard that we have made that goes out with every new membership of CLAN, and it's a black one with white writing. CLAN remembers all care leavers who have died never getting respect, records, redress, reunited with their families, and we've had to add a new one to those 4 R's, those rejected by National Redress. We would like to put our attention to foster care children who were state wards of each state government who are placed in foster care or holiday hosts who get rejected by NRS. We'd like to speak about the lack of consistency, the lack of awareness in nursing homes and aged care facilities, procedural fairness. I think the organisations, the churches and charities and state governments have had procedural fairness since white men came to this country. The victim stroke care leaver state wards haven't had procedural fairness until the Royal Commission was implemented. And there's so much pushback now in National Redress. It's incredible. I heard a previous speaker from the Catholic Church who mentioned Ireland and Scotland. Scotland is so generous that they give redress to the descendants of care leavers abused in their orphanages. What a generous country. They're probably using our Victorian redress money to do that. Because, you know, Scotland got Victorian taxpayers' money to run the Commonwealth Games. I think the wording in IDM outcome has to be addressed. And Natalie, I'll hand over to you, love.
Hi, yes, we would also like to discuss the timeframes that the applications have and are spending in each stage. We would like to discuss the use of the S24 letters, which we believe are contributing to the backlogs and also re-traumatising care leavers. And we would just like to mention the lack of communication that the RSS, other RSSs and us are experiencing in trying to communicate with DSS and the National Redress Scheme.
Thank you, Natalie and Leonie. Is that the end of your opening statements?
Yes. You can go into question. Yes.
Now, first of all, thank you for sharing your opening statement. And Renee, you've already got your hand up, so I just wanted to check in. No, she's taken it down. So you've given us some very...
sorry, Jodie. I thought I was on different mute. I have a question whenever you're ready.
Yes, off you go.
Oh, excellent. Thank you. Thank you so much for your submission, Leonie and Natalie. My question is around, and I understand you've been listening to the hearings so far, is around the communication of the scheme out to the wider community, but in particular vulnerable communities. And we've heard people speak about the challenges of getting into communities of people with disabilities, languages other than English, First Nations community, regional remote, people with poor literacy or mental health, and the incarcerated. In your submission, you speak specifically about the challenges reaching elderly people who might be eligible for the scheme. And with the scheme's closing date fast approaching, I was hoping you could speak some more to us about those challenges and what you think needs to happen to reach out to more elderly people.
Natalie, do you want to speak?
I can start off with that one, but we know that there was a whole work of outreach work done by the scheme to target inmates, and we think a similar tactic needs to be taken with elderly care leavers in aged care and other groups where we know that elderly care leavers reside. I mean, as an RSS, we've done our best to send information to places like caravan parks, to GPs, to hospitals, to aged care facilities. But coming from a group is not going to hold the weight it does as if it came from the government, from the scheme itself. So we think a whole lot more needs to be done to target this group, as we're still receiving calls every week from care leavers in their 70s and 80s and 90s who have never heard of CLAN, and they've never heard of the scheme, and they've never heard of the Royal Commission. So there's a lot of people out there who still are completely unaware that any of this exists, and they really should be our main demographic that we're targeting, because obviously they are getting older. They do not have the time that other groups have to seek redress before they pass away.
I'd like to add to that the Minister for Aged Care and the Minister for Health, Mark Butler, I can't remember who's the Aged Care Minister now, and I think there could be some awareness raising done through the ministerial meetings of aged care providers and aged care ministers. They have a 6-monthly meeting. There you don't see any, you see lots of ads for lawyers flogging their business, but we don't see ads where mostly elderly people who are infirmed in nursing homes, they watch a lot of telly, and there's no ads to promote the redress scheme. You know, I just took a call yesterday from a 74-year-old lady. She's a candidate for National Redress. She's never heard of it. A lot of this cohort of people, they don't even hear about the Royal Commission. You might be surprised about that, but they turn off anything to do with child abuse. They switch off. But, you know, she's coming to Melbourne to meet me tomorrow, so we're going to do her Victorian redress and her national redress. But there needs to be a lot more, you know, awareness raising in elderly Australians. They shouldn't be missing out because the government haven't promoted the scheme in that cohort of people. I'd like to pay acknowledgement to Tanya Plezebeck and the leadership of Redress, Michael Lai, when common sense prevailed and they acknowledged that women, as girls as young as 8, had those virginity tests, or state-sanctioned rape, as we call it. We don't call it medical procedures, for goodness sake. that they acknowledge that as child sexual assault. So I want to thank the government for doing that, and more people are coming forward. And that lady yesterday, she had that awful procedure done, not in a children's home. She was taken to a doctor's surgery, right? So yes, in that case, it was a medical procedure. But many of these children, state wards, had it done inside orphanages and children's homes.
Thank you so much. Just a follow-up question. For the elderly people who are made aware of the scheme and do interact with the scheme, how well do you think the processes and supports are servicing that cohort in particular for them to work through their claim?
Natalie, you can do that one.
Yeah, so
Sorry.
That's all right. As an RSS, Clan does the majority of that supporting. So, we take them through from start to finish. We will assist them in every aspect, to do with their application form, as well as the emotional support that they require along the way. That the delays are the biggest thing, because obviously if their applications aren't fast-tracked, being the ages that they are, you just never know what can happen even if they don't have a terminal illness. So that is a limitation. No matter how well we support them, we can only work within the limitations of the scheme and what the scheme provides to us. The other issue, as I mentioned earlier, is the communication and liaison that we currently have with the scheme is quite poor, which then means we are obviously struggling to get answers to advocate for these elderly people that we need to, because we just can't get through to somebody. We're not getting answers back. We don't have the quick communication that we need to in some of these cases. So in terms of the support that's provided to them, we can do that all on our end, but again, it comes within the confines of what the scheme can provide to us on their end.
So, Natalie,
Excuse me, Chair. Oh, sorry, go on.
Yes,
sorry.
Yes, Leonie?
Is that Renee or is that...
It's Jody.
Jody.
Yeah. What
Jody,
did you want to...
Our relationship... I wanted to say that we had a very good working relationship with Redress, National Redress, with a dedicated person, and she's been moved to do the 8th-year review. We haven't got a consistent person. We're now dealing with the director. And I really, really wish that the Joint Standing Committee was having these hearings every 6 months, because goodness me, we've had magically some outcomes from people who have waited 3 years. We've magically had an outcome for these people, just in the last 2 weeks, because the lead up to this hearing, these elderly people waiting 3 years, and, what happened to reasonable likelihood? That seems to have gone out the window in the policy section, because that's what we were assured of. We believe you don't need records, and now it's institution focused. Now it's, to send these S24 letters to people who've waited and waited. Ebon, who's 81, yes, she got an outcome last week, but she's been waiting over 3 years.
So,
and another bloke's been waiting. Go on, sorry.
So, Leonie and Natalie, I think one of the questions that we have as a committee is around why are the delays occurring, and what do they look like?
Well, I guess that's probably a better question for DSS and NRS, but on our side, a lot of the delays are administrative delays. I guess a lot of the delays are coming from the institutions responding to the FOI requests. At the moment, I feel like a lot of delays are caused by the S24 letters.
Natalie, Natalie,
yep.
Can you drill into that a little bit for us?
Sure. So to give you an idea, we get S24 letters sent, and they'll have a whole heap of information. That the difference now with these S24 letters, we used to get asked questions, which were pointed questions. And in some cases, they were completely uncalled for, but they were to the point. Now we just get these letters sent to us with all the answers that the institutions have provided, and it's a guessing game for us to try and interpret what is it that the IDM doesn't like in the answers that they've got, what are they finding inconsistent, what do they want clarification on. Leonie mentioned Yvonne before, who had waited 3 years. She just recently got an outcome, but that was after about 3 or 4 S24 letters were sent. The first lot was some pointed questions, which were uncalled for questions, asking an 81-year-old what a building looked like that she worked in, asking her what the clothes looked like that she used to sew, who paid her wages when she was 16, questions like that. But then we get S24s asking, well, not asking, but providing us with information about where her brother was in care. We're wondering, why are they sending us information about where her brother was in care? How is this relevant to Yvonne? Similarly, they want explanations about prior payments. However, in these letters, it is obvious they have all the information about prior payments. But when they're pressed on it, they want confirmation and they want the documentation that the care leaver has about the payments. So we're actually, I think we've got about 3 or 4 lately about payments. So victims of crime payments, Victorian redress payments. We actually had one for an 87-year-old man whose application was put into redress many years ago by himself. It was assessed without one of the institutions as they hadn't joined yet. That institution has now joined. Redress sent him a letter asking him if he would like his application to be reassessed because this institution has now come on board. He signed the letter, sent it back. We are now getting an S24 as to what the prior payment was that he received. The prior payment was the NRS payment that NRS have given him. So this is the sort of thing that is backlogging the system and taking up our time to attend to these S24 letters, to write responses. And then the other side of that logistically, which we're finding difficult working in with NRS and DSS workers, is that they're not communicating with us as to sending us the paperwork that we need to do the S24s for these care leavers. So care leavers are getting the letters themselves. And even though we are their nominee and should be receiving a copy as well, and I would argue prior to the care leaver receiving it, so that we can then support them, warn them, they don't get a shock when they open their mail, they're not re-traumatised by reading this sort of thing. We're hearing from the care leaver, by the way, I've just got this letter and it's 2 weeks till it's due, and we don't have a copy on our end. So these sorts of logistical matters as well is what's making it harder, and then we need to request an extension to be able to get the letter and to provide a response in time.
Thank you. So you've described some of the detail of the activities that are taking up time and seem to be inconsistent. Do you have any feedback on what the department could be doing differently, or what the department may need to be able to undertake their role more efficiently?
Leonie, did you want me to speak to that, or?
I think that, giving organisations 6 weeks to get back with this information. They've had years and years to know that there would be a request for information, and then they can extend and ask for an extension. They get 12 weeks. There should be no extensions given to organisations. They've had long enough to get their act together. Natalie, do you want to finish that one?
Yeah, like I said, if communication was better from the NRS, if we were receiving these S24 letters prior to the care leaver getting it, as we used to beforehand with the worker that we had, it makes it a lot quicker. And then just we shouldn't have to be providing S24 responses for information they already have. They've got all the information about victims of crime payments, about Victorian redress payments, about the NRS payments that they've provided themselves. We shouldn't be wasting time on this sort of information.
I'm going to get into the weeds a bit, Natalie and Leonie.
Yeah.
Would it be more beneficial for the department to meet with the redress support services with the client? Would that be more helpful? It feels like there's a lot of...
No. But look, if we're talking about the government's children, state wards, wards of the state, they don't trust the government, right? And redress is the government, no matter how much you pretty up and say it's from DSS. It's a part of government. Sure, they should be meeting the people that they reject. The IDM should have a face. We should be able to know if it was a female or a male that made a decision to reject your application. We can't even know the sex of the person. I don't call them an IDM now, I call them it, because I don't know their sex, right? I would like to read you what the Victorian State Ward, when I talk about the lack of consistency, I want to talk to you about the day I got 4 outcomes. There were 4 Victorians who were in foster care. 2 women got 150. They were sexually used in foster care. The 2 men got sexually used in foster care and they were both rejected. We don't put enough focus on the people who get rejected by NRS and who don't get believed. How can, I've asked NRS to define who's responsible for state wards in foster care or holiday hosts. They can't come back and tell me, why do these people get rejected? And I will read to you what a man gave to me on the 6th of March, and it took an enormous effort for him to write this email. I was not happy with the decision of the National Redress, as I had to wait 18 months for a decision of no. And I feel that the department, DHS, is still responsible and should take responsibility and be accountable for what happened to me when I was under the department's care as a Victorian state ward in foster care. We don't talk enough about what this National Redress is doing to people who've been rejected. Every time there's something in the media, they're going to be triggered. And how can a caring country like Australia invite these people who were the children of the governments of each state to come and tell your sad story of being sexually used and then reject them because of a technicality of, who was responsible for putting you in touch with the pedophile? Well, the state governments paid these foster carers to look after you and they didn't do their duty of care and didn't look after the state ward child. And yet our government rejects their application. So you get no financial payment, you get no apology and you get no access to counselling. Now go away and live in your country town and don't bother me ever again. We don't care about you.
Very powerful statement there, Leonie. Thank you for sharing that with us. You have in your opening statement listed a number of things that you wanted to talk about specifically. Is there anything that you haven't discussed in those areas that you'd like to bring attention to? You talked about pushback. And I wondered what that, I made a note of that. What does that mean, and what's that in relation to? Can we revisit that?
We've never even heard of S24s until about 3 years ago. There was no such thing. Correct me if I'm wrong, Natalie, and I am wrong many times, so come in and clarify, please, Natalie, if I've duffed up.
Yeah, no, the S24s, when they change to, asking questions like this, and the way in which they do it, as we were saying, that's the thing that's causing all of the issues. They're not clear. There's no consistency. They don't actually specify what they're asking for. You're just provided with a whole bunch of information, and it's a guessing game. And the heart of a lot of them is the records issue of, we don't have records of this time, and the IDM's reliance on records, knowing very well, through all the work that has been produced through the Royal Commission, we know of the difficulties with records. We know that some places don't have records. We know record keeping was poor. And yet there is such reliance on records and the institutions to confirm that somebody was in their care on a certain date. And then also an expectation that people in their 60s and 70s and 80s are meant to recall down to the year, of when they were in care. And some institutions getting around it by saying, well, they weren't here in those years. It's, that's where it comes back to Leonie saying, what happened to we believe you and reasonable likelihood? These are all the impediments that civil litigation had, which national redress was supposed to overcome. And, the IDM's reliance on records isn't overcoming this.
Chair?
Yes,
I think
Leonie.
the wording of IDM statement has to be addressed. Natalie,
Yes.
Can you please read that statement? It is so awful. How could that leave national redress and be posted out to a care leaver and to Clan? And, I spoke to that care leaver last Saturday, and he told me when he got the letter, Natalie will read it in a minute, he threw it on the floor, and that's where it stayed for 3 days. He was so disgusted in what that person had written. It had written. I wish we knew the sex of these people. It's terrible calling people it. Why can't we have their, first initial? Make them more humane. We should know if a man is making a decision or a female is making a decision on your application. They know all about your personal private life, what happened to you as a child, but we can't even know the sex of the IDM. And that IDM just sent that letter. I can't believe that was allowed to leave Canberra to go to Tamworth. Natalie, could you read the disgusting words, please?
Sure. This is a care leaver that I've supported through the redress process, and he has consented to us using his words here today, or using the IDM's words that were sent to him. In the reasons for the redress determination letter that was provided to him, the IDM has stated, the scenario described by the applicant is bizarre. It has a hallucinatory quality to it, and it would be remiss of me not to have considered whether it might possibly be the product of mental illness. On the basis of the information before me, I'm unable to make any meaningful assessment in this regard, so I've set this consideration aside. It then goes on to say, because it is such a strange and unusual scenario, I've struggled to find that the abuse described reaches the standard of reasonable likelihood, the test under the Act. On the other hand, reports of life at Royalston are so negative that I've been reluctant to reject the applicant's account. In addition to the general cruelty and bleakness of the care regime at Royalston, sexual abuse of residents was apparently common. I therefore determined to accept the applicant's account and find it is reasonably likely. And of course, there's other wording, but this man was given an outcome, and he was given the maximum of what he could get for the type of abuse he endured. I can guarantee you, after spending 15 years doing this job, that his application was not very bizarre compared to many others that I've done. And the fact that he could be given redress and these words still provided in a statement of reasons for him to read is completely unacceptable. How can anybody, get this as part of their redress package and still call it redress when they've been accused of having a mental illness in the letter?
Perhaps sorry, Chair. Perhaps you asked what are the stumbling blocks. Perhaps they need to lessen their written report when they're giving that report. We don't need to hear about Royalston in the 1940s and the 1950s. He wasn't even there in that orphanage. What relevance are those points in an outcome letter? And how dare some IDM write, we think this is mental health, issues. Just make a decision on the application's sexual abuse, mate, or her. We don't need you to theorise in this outcome letter.
Natalie, I just want to acknowledge that letter, and I'm not sure whether you've got permission from the person that sent that to you to share with us as a committee. If you haven't got permission, whether you could possibly, and whether that could be submitted on notice.
We do. He gave permission to share it.
We do. We both spoke to him.
That would be useful. When was that letter sent, out of interest? Was it March this year?
After we put in our submission, so it would have been sent, I believe, late February, early March.
So if we could ask for that, a copy of that to be sent to us, that would be great. Now, I'm conscious that there is a need to suspend the recording or the broadcasting as you wanted to speak offline, correct?
Yes, please.
And so we can do that now, but I just, Dean and Renee, do you have any questions before we do that?
No, thank you.
I might, thank you, Chair. I might just ask Leonie for whether she had an opportunity to read or to hear about the Australian National Audit Office report into the scheme, and whether she'd like to make any comments in regards to that.
No, I haven't had time to do that. I'm very, very busy helping elderly Australians put in a submission, and with the Victorian redress, that goes for the next 4 months. Breadcrumbs they give you in Victoria. There are a lot more people applying for that. And so our work is cut out for us. I don't get a lot of time, and probably Natalie hasn't read that either, but if you can send us the link, we'll certainly commit to scanning it. We won't be reading any words. But I heard some evidence today, and I was staggered that the Catholic Church couldn't come up with ways to promote the redress scheme. They have magazines, they have church on Sunday, they could talk from the pulpit, they could invite victims to apply for redress. There's so much more the Catholic Church and all the churches and charities could do. The onus is on them to help victims of their orphanages and children's homes, foster care, missions and that, holiday hosts. And they don't. They need the blowtorch applied to them, as far as I'm concerned.
Thank you very much. Thank you.
Dean, are we happy to suspend the broadcast?
Yes, please.
Hello, how are you? Good morning. Or afternoon, nearly. I'm Jodie, how are you? How are you? Welcome all. Have a seat, yes, Eva.
Thank you. Does anyone mind if I take my shoes off? I just need to have my feet flat on the floor. Thanks. Thank you.
Kick off. So the committee will now resume proceedings. I'd first like to introduce those of us that are here today. I'm Jodie Ballier, the Chair and Federal Member for Dunkley, which is based in Victoria. And we've got online the Deputy Chair. Dean, would you like to introduce yourself? Maybe he's not quite back. Renee?
Yes, hello, I'm Renee Poppy. I'm the Federal Member for Griffith in Brisbane.
That's okay, thank you. Dean, are you back yet?
I'll just wait a minute.
Yeah.
He gets back.
Should I read my...
I might just suspend again briefly. Just suspend until...
We'll just suspend.
Resume the hearing? Yeah.
Yes. Off you go.
Good morning. My name is Dean Smith, a Liberal Senator from Western Australia and the Deputy Chair of the committee.
Wonderful, thank you. I now welcome all of you as representatives from the National Centre for Action on Child Sexual Abuse to give evidence today. For the benefit of Hansard, would you please state your full name and the capacity in which you appear before the committee?
My name is Laura Jane Phoenix Singh, and I'm a lived experience advisor for the National Centre for Action on Child Sexual Abuse.
Gillian Bush, I'm the CEO of the National Centre for Action on Child Sexual Abuse.
Sandra Collins, a lived experience advisor for the National Centre for Action Child Sexual Abuse.
Robbie Daniel Neil Gambley, lived experience advisor for the National Centre.
And I'm Lucy Knox, the Director of Lived Experience at the National Centre for Action on Child Sexual Abuse.
Thank you. Thank you for all being here. This hearing is a legal proceeding of the Parliament and it has the same standing and proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Do you wish to make an opening statement before we proceed to discussion?
Yes. Thank you. I'll start and then we'll have our three lived experience advisors will speak as well. So thank you, Chair, and also thank you to the committee for the opportunity to appear today. As I've said, I'm Janine Bush. I'm the CEO of the National Centre for Action on Child Sexual Abuse, and I'm appearing with Lucy Knox, who's our Director, as she's explained, of lived experience, and also our lived experience advisors who've introduced themselves. And I also want to thank them for sharing their experiences with the committee today. I also acknowledge that we're meeting on unceded Aboriginal land, the land of the Ngunnawal people, and pay my respects to Elders past and present. I also extend that respect to First Nations people present today. The National Centre is an independent organisation established following the Royal Commission, and our role is to improve how systems respond to child sexual abuse. We do this by bringing together lived experience and evidence and by being clear about where systems help and where they cause harm. One of our core goals is to make sure that survivor experience shapes national decisions. That's why our submission reflects both lived experience and what we see nationally about when survivors are able to come forward. The creation of the National Redress Scheme was a significant achievement, and for many survivors it's been life-changing. It's offered recognition, acknowledgement and a pathway to justice. But we also know from survivor feedback and evidence that the scheme hasn't worked well for everyone. For some people the process has been complex, distressing or re-traumatising. Others have experienced long delays, difficulty accessing support, or outcomes that didn't reflect the harms that they endured. These experiences matter, particularly for people who've already waited decades to be ready to engage. From a systems perspective, the central issue before this committee is how survivors seek redress and whether public schemes are designed around that reality. What we see consistently is that readiness doesn't follow a timetable. Many survivors are only able to engage later in life, once safety, stability or trust has been established. If access to the scheme is closed before that point, those survivors are effectively locked out of redress, regardless of the legitimacy of their experience. That exclusion causes further harm and undermines confidence in the public commitments made after the Royal Commission. From the National Centre's perspective, challenges in how the scheme operates are not a reason to close access. They're a reason to improve how the scheme works. We recognise that issues such as delays and administration need attention, but those challenges shouldn't determine whether survivors can apply. We're also mindful that governments operate within real funding constraints, And our point would be simply that the need for support doesn't disappear if access to redress ends. The cost doesn't go away, it just shifts to somewhere else in the system. Looking ahead, we're concerned about what happens beyond the scheme. Planning for survivor access to justice and support can't wait until 2028. It really needs to begin now. In our submission, we also stress the need to plan beyond the life of the scheme. Survivors will still need legal support. They will still need access to ongoing support over their lifetime. So thank you. We welcome the opportunity to assist the committee in its work while we're here today to answer your questions. And I will hand over to Laura Jane, who we also call LJ.
Thank you for having me. My name is LJ. I'm a proud Aboriginal woman. I am an academic and I am an advocate. I was born on Ngunnawal country, raised on the east coast of Australia between Batemans Bay on Yuin Nation and Meanjin on Turrbal and Yagara country. For the past 9 years, I have called Wadawurrung country home. Before anything else, I am a daughter, a granddaughter, a mother, a sister, an auntie and a wife. But today I stand here as a victim survivor of institutional child sexual abuse and child sexual exploitation. I'm here to remind the committee of the failure of the redress scheme, not just for me, but for many other people like me. I was 23 years old when I gave evidence to the Royal Commission in Meanjin. I believed in it, I believed in what it promised. Closure, justice and recovery. But after 4 years in the scheme, my claim was rejected. It broke me, a promise betrayed. Because of this failure, I and many other victim survivors like me and our families have been forced into civil court. My case has already been going on for nearly 5 years in a violent system that is not trauma-informed, but one that has commodified and capitalised on child sexual abuse. The failures of the redress has a lot to answer for, including this. I'm still seeking justice for a harm that occurred within an institution over 25 years ago, but in a way that replicates the very abuse I have already endured. My story is not unique. My voice represents the voices of many. The redress scheme was meant to be an alternative. It was meant to spare us from this. If it had worked as intended, if it had honoured the promises of the Royal Commission, we would not be here. Instead, the legal system has decided to profit off our pain. This harm is not equal either. It is deeper for those who are already marginalised, especially more. Aboriginal children have always been overrepresented in institutions. From the stolen generation to today, we are overrepresented in out-of-home care, in youth justice and in prisons. This is not accidental. This is the ongoing impacts of colonisation, the very system where institutional abuse began. And yet the redress, the so-called pathway to justice, fails this cohort the most. The very children most impacted by institutional harm are the ones most likely to be excluded, disbelieved or re-traumatised. Children are still being abused in institutions today, so I ask, what justice will they have? What option will exist once the scheme ends? The only pathway will be civil court, where institutions are protected, where survivors are worn down, where lawyers profit, and where people become suicidal under the weight of it all. Who is accountable for that? Where does change actually happen? When will the promises of the Royal Commission be realised? Because none of us are free unless all of us are free, and right now victim survivors are still trapped in a system that promised justice, protection and recovery, but instead continues to harm. 10 years on and we are still waiting. I am still waiting. I will likely be in court for many years to come. My life is on hold. I am suffering, my family is suffering, and another cycle is repeated. All I wanted was justice, acknowledgement and accountability, and yet today all I have received is further trauma and further harm. It's heavy, I know. I want to know how we are expected to survive this. Why must we keep carrying what was never ours to hold? The scheme has deepened the harm for those already subjected to brutal and violent abuse. We are people, we deserve justice, we deserve a pathway out, and that should have begun with accountability.
That was great, LJ. As you know, I'm Sandra, a lived experience survivor. I'm also an activist who's aligned with the National Centre. It's an honour for me to represent other CSA victims survivors today. I invite all of us to take a deep breath now. for those of us who haven't made it through. I have slipped through the cracks many times in my life. I learnt at a young age that the system wasn't there for kids like me. All these decades later, this situation still holds true with my experience of the redress scheme. My grooming began when I was in nappies. I was born into a pedo-patriarchy built on the bones of children's stolen innocence. I have risen from death, not because I wanted to, but because I was willing to live to protect other kids. I existed fully inside an atrocious nightmare for over 19 years. I carry strength, resilience and wisdom that you cannot measure. My hypervigilance is such I can map danger before it even has a name. I am, as others are, plundered and ravaged prisoners of severe childhood sexual trauma, with bodies labelled used goods by society. No Victoria Cross for us, even though I was extremely brave in the presence of my enemy. No validation like war veterans, no lifelong tailored programs for our changing needs, including navigating intimate relationships. I was informed about the redress scheme by an agency dealing in other matters, with no access to information options about entitlements. I was forced to make an uninformed decision about what was available. What I received only touched the edges of payments I continue to make and that have kept me on the poverty line all my life. I notice a real lack of equity in the scheme. Institutional abuse was given preference when most CSA happens within the family, as mine did. Where is the equity for familiar CSA survivors? In a family setting, there are many types of sexual abuse and torture, plus duration of abuse compounds the trauma. How come this isn't being given the focus it deserves? There needs to be a substantial increase in the amount of redress offered according to individual experiences. Thank you.
Thanks, Sandra.
Chair, Joel, I brought a photo if you would like to see this. Thank you very much. My name's Robbie Gambley, thank you. The significance of that photo is my family was struggling. My father had beef cattle properties and we didn't have a camera for about 10 years. And it was just by chance. We had a lot of horses and red Kelpie cattle dogs and chooks and everything on the farm. And there was a Boy Scout that came. I was in the Boy Scouts and he came from Brisbane and he absolutely loved the property and seeing the chooks and the cattle and the dogs. And he'd say, Robbie, can you take me for a ride on Brownie? And that photo was taken before the horrific abuse. And to me, that shows the wonderful, beautiful, glorious innocence of children, the way they should be and the way they have a right to live their lives. Thank you. It's truly an honour to speak here today. Firstly, Chair, I would like to thank you and the committee members for doing this difficult work. I also ask, please don't look at me the way I am now. Try to imagine a 14-year-old young, naive teenage boy living on an isolated cattle property. That's how I was when the abuse started and continued for 3 years. I was attending Benalbo Central School. where the perpetrator, a science school teacher, operated. Please remember that brave survivors were children who had their glorious lives ahead of them, as I did. I gave evidence to the wonderful, the Honourable Justice Peter McLennan AM. I was treated extremely well by the Royal Commission people. I gave my evidence in Sydney. I trusted the Australian government would listen to my story and the stories of other brave survivors of child sexual abuse. I submitted my extensive application with my police statement and many supporting documents in pristine condition to the National Redress Scheme. My package was about 1 inch or 3 centimetres thick. I worked very hard on my NRS application. Then I found out about No More Legal Service. I spoke to them. I rang the NRS and asked to withdraw my application. I spoke to a male. There was silence. Then I asked, so what happens now? I get my documents back. I was told very bluntly and coldly, your documents are being put on digital form and your originals are being destroyed. They only had my documents for about a week and a half. There was no respect, no empathy. I was crying after that horrible phone call. Photocopies of my pristine papers were posted to me. They were terribly faded, out of order, a total mess. With No More, when the NRS was ready to make me an offer, there was supposed to be a 3-way phone call with my No More lawyer, the NRS and myself. That did not happen. The NRS people, a lady, rang me. Mr. Gambley, we have your offer. Shall I tell you the amount? Words to that effect. This person just went ahead and told me my compensation amount, a pathetic, cruel amount without my No More lawyer. The phone call was ended. 5 minutes later, I was in tears again, crying. I composed myself and rang my No More lawyer. She was very disappointed with what was done. I was determined to get justice. I waited for second chance civil action in New South Wales. I found an excellent lawyer, a compassionate lady. The second chance civil action payment I was awarded through mediation was better than the NRS. The NRS was far more traumatic than the second chance civil action and the mediation I went through. For me, the NRS has been a painful and shameful chapter in Australia's history. The dreadful wrongs of many decades of neglect and child sexual abuse could have been put right, but it has not. Brave survivors have been traumatised all over again, and this never should have happened. Thank you.
Thanks, Robbie. Urged on everyone to take a breath. Thank you, LJ, to Sandra and Robbie for your personal stories and sharing of your experiences, which I'm feeling a little emotional, and I'll share that. I have my own lived experience, and I'll just, because you've declared that, of sexual abuse. So I understand what it takes to be here today and to rise above that and use that as, in some respects, your personal power that propels you forward through life in a way. So thank you for sharing that with us. There are questions we've got, but I suppose you've given us 10 recommendations and in your summary. So my comment or questions to you are, you've had lived experience of or bad experience with the National Redress Scheme, and it's really understanding the focus of this inquiry is about the scheme and where it's at, and how do we improve it and work towards some solutions. There have been a number of inquiries and reports done prior to this, and there is a new department, a team leading the department. So for me, it's about understanding what do you think are the priorities in terms of where we stand. I've heard about delays and access, but yes, Janine, I don't know whether you've got more, Lucy. And then I'll also ask my colleagues, but we'll start here.
Look, I can start with the top three areas that we would consider priorities. And one is resourcing redress support services to make sure that survivors who've applied are properly supported through to a final outcome, which I think is what we've been hearing from our lived experience advisors who've participated in the scheme. The second would be extending the National Redress Scheme. So while it hasn't worked, we're still at the point where we feel that those who haven't been ready are not excluded by an arbitrary application closing date. And then thirdly, planning now for what needs to come after the scheme. And we of the view that there needs to be consultation with survivors about the longer term supports that they'll need beyond redress. The planning is really critical, and I think these align with other reports and inquiries. But I'll hand over to...
Can I ask LJ and Robbie particularly the determinations about both of your cases? So it sounds like it was some time ago, LJ. Is that the case?
Yeah, so I applied
in the beginning.
I applied for the redress the minute it opened.
Right.
And my claim was rejected in 2021.
And Robbie?
I put my application into as soon as it was announced, and
And this is a bit of a hypothetical question, but if you were to apply now, do you think there would be a different outcome?
I don't know. May I speak?
Yeah, of course you can, Robbie. Yeah.
I attended a meeting, a roundtable meeting on the National Redress Scheme with Dr. Kathy Kazerman in 2018, and many proposals were put forward. I think there were 3 Aboriginal groups speaking. I ended up speaking quite a lot. I spoke about Scotland's redress scheme, which is, as I understand it, about the equivalent to 185,000 AUD. What saddened me was, and extremely disappointed me, was that, all these ideas that were put forward and suggestions, it just didn't. There was no action on it. That wasn't taken forward. So that was extreme. That was extremely disappointing. And as far as I'm concerned, I don't know what I'd do if I did it. I did it now, because it just doesn't seem to be a good system. It wasn't fair. It wasn't. And I think Sandra spoke very eloquently, and LJ, about what they've been through. It's just such a difficult system to go through. It was cruel. I know. I added a comment here. May I put this? The NRS was never meant to be a full compensation system for the horrific abuse that happened. But by the same token, it never should have been an instrument of cruelty. And to me it was.
And can I add a comment to that? I also applied for the redress scheme, and I felt incredibly vulnerable. And I had my therapist's support to do it. And I was terrified I wasn't going to be believed, even though I knew it was the truth. And I had to literally spill my guts about stuff that even my daughter doesn't even know. And I found that was asking an incredible amount of money, an incredible amount of me for the amount of money, that was being offered. And which brings me back to my opening statement. It's like, it's not just some sort of cover like umbrella CSA. There are so many layers and levels. And a lot of people have different kinds of proof for what they've been through, either physical conditions or mental, emotional. I myself have been in therapy since I was 20. I am 69 in May. That's how I got through my life, and I had no family support. I had to move to separate from my family, and that means I've been on the poverty line all my life. And it's a great honour for me to be here to use my voice to speak in Parliament, and I can't help but wonder, you know, what is going to come out of this? What justice is going to be done? Yeah.
Thanks, Sandra.
I don't know if I might have had a different outcome, and to be fair, I'm not even sure if I can comment on that because I'm in civil court. I can tell you that I came to the scheme with information I gathered myself. I did all of the freedom of information from the institution, from child protection, from other victim survivors. I can tell you that No More fought pretty hard for me, and the lawyer was shocked, really, that my claim got rejected. And I think that the violence of civil court is comparative to the violence of the redress. And I think, honestly, I would prefer to have done neither, because I could be in civil court for 5 years, another 5 years on top of the 5 years I've already been in there. And I think that as someone who gave evidence at 23 years old, 12 months out of active addiction, I think that the redress let me down, because I was promised a positive outcome, and 1 year out of COVID, they were like, sorry, no. And they talk about the reviews, but it's a lot to ask someone to have your abuse reviewed by someone who isn't a social worker. They aren't a politician. They aren't a subject matter expert. And I can't help but wonder, the Royal Commission spoke about removing the burden of proof. At no point through the redress scheme or my processing of that did I feel like the burden of proof was removed. I felt like, if anything, I was having to prove what had happened to me and who was responsible, and that just wasn't my job. And I'm lucky enough now to be an academic, and I'll spend my life fighting for victim survivors. But my story is not unique. This is the reality of so many. I'm in a redress support group where there are people who are quite literally losing their lives and are waiting 5-6 years and are now being, having the burden of proof fall on them. It was supposed to be an alternative, not to civil court. It wasn't supposed to replicate it.
May I add something to that?
Yes, of course.
Thank you. I found the section of giving my evidence and for it to be reviewed by an assessor, that, as LJ has referred to, that terrified me. That was so frightening. And correct me if I'm wrong, but as the system when it first, the scheme when it first started was, I thought about appealing the amount I was offered, the pathetic amount I was offered, but back then there was a risk of the way the system was legislated was that I could be actually offered less. So that was absolutely terrifying. And the one good thing for me out of it, and I have to say this, was No More. No More were just absolutely amazing. I had the most wonderful lawyer who worked and worked and worked for me, and I understand they were started with the Attorney General's Department. So that, without No More, thank you for having No More, and I hope No More continues to get great support. So, yes, it was just such a frightening thing to go through, and I'm in a similar situation to Sandra. I was very close to my father, but my father passed away. I have no family now. I'm lucky that I have some friends who support me, but I live in a country town, and there's some people that just don't want to know about child sexual abuse. But I've been very public, and there are people in the bank, the chemist shop, different that have been very kind to me. But it is a difficult subject.
It's a very difficult subject. Dean and Renee, do you have questions?
I do. Thank you very much, Chair, and thank you very much to you all for your participation and for sharing your experience. The National Redress Scheme prides itself on being trauma-informed, but what I hear from your evidence is that while that might be the claim, there's a very, very large gap between people's experience and that claim. I just want to turn to a matter that was raised with us in some previous evidence, and it goes to the importance of the direct personal response which is offered in the National Redress Scheme, and how important that is generally in part of the healing process, and whether or not there might be any understanding or explanation about why it's being not pursued by survivors. And I'm just wondering whether or not, just bear with me one moment, whether or not someone might be able to provide some explanation in regards to that. Perhaps Dr. Bush, you could provide any observations about that.
I might hand over to Lucy, who oversees our lived experience work.
And I might also ask Sandra, were you offered a direct personal response? And an apology? Were you offered an apology as well?
No.
Yeah. Yep. So I think absolutely we have heard from many survivors who have received a direct personal response, although it is a small number, that it has the potential to be really powerful. It's a really significant part of the response of the redress scheme. I'd be interested to hear from the group whether you have ideas about why direct personal responses are not being taken up.
So I would reflect on timing. If you've had to, my claim got rejected, but what I can tell you is that the reason I pursued the redress outside of financial compensation, which I think every person that is abused in an institution deserves, is because I wanted an apology, I wanted accountability, I wanted acknowledgement that an institution let me down. But I think when you're fighting for 4 years against someone who's literally trying to say that they aren't responsible, a response seems kind of inauthentic in the end, right? So if they're saying, well, no, this, we're not responsible, and then by default they have to compensate you, it's pretty inauthentic for them to then apologise later. And from what I've seen or witnessed by speaking to other victim survivors, that's often the response. And institutional abuse is rarely, if ever, connected to one institution. It's often systemic and structural. So if you have one organisation that's funded by another, that's funded by another, who are all responsible for safeguarding, technically we need to look at who's apologising and why, and how authentic is it? Because for most of us, we're paying for we're paying with our lives for the abuse that we've experienced, and it's more than one person that's responsible for that. And I think that people are looking for justice, and the justice is more than a letter or an inauthentic apology. It's what are you doing to change it, and what does that actually look like? I have every report ever published by the Royal Commission, and that was the purpose of the Royal Commission, was not just to compensate us and apologise for what we've been through, but to create systemic change. And the apologies, their personal apologies should have been able to demonstrate systemic change and how those institutions were going to enact that. It's not sorry doesn't mean anything if you keep making the same mistakes.
Yeah. And I have a comment too, please. For me, the whole process felt very cold and clinical, kind of dissociative. I wasn't dissociative, but I felt the process was dissociative. The whole thing of having to condense my situation into a box and have unknown people read it and assess me was kind of gave me this like crazy making feeling. It was so impersonal, and when someone is sexually abused, that's what it is. It's impersonal and it's invasive and it's traumatising, and I nearly didn't apply because I could tell I felt powerless, and I kind of went, well, you know what, so I'll get sorry, and will I or won't I get some financial recompense as a single mum who's lived on the poverty line all her life? And I kind of gave up, really, and then someone inspired me, and I thought, well, I've got nothing to lose. But it's that whole the process, the bureaucratic process of having to have paper and proof and these unknown people looking into you.
And you're required to write in detail the abuse that you've experienced down to the very specifics of that. So to do that, and then, yes, you get money or you don't get money, but someone is then deciding the validity of your experience. You want an authentic apology. I don't want a bureaucrat to sit in front of me and be like, so sorry, here's a letter that's signed by our CEO that they probably never read, so that you feel better about yourself. We are looking for authenticity. Child sexual abuse is one of the hardest things to recover from. And we know that through research. We know that through international understandings. We also know that through the impacts of colonisation. An apology must be authentic, otherwise it doesn't mean anything. And when you talk to victim survivors, whilst it can be life-changing, for many people it is an inauthentic experience, and that's not fair. Not when you've asked people to go into specific details of the abuse they've experienced, to have it categorised, and then a financial amount decided based on your abusive experience, because how are we comparing? Child sexual abuse is bad whether it's one time or 500 times. It's never acceptable. So you're quantifying abuse without considering that abuse affects us always, all the time. No one's waking up the next day being like, I'm sweet now because I got a letter and I've got some money. We have to live this forever, and that is what the Royal Commission clearly discussed by its evidence, and that should have been taken into consideration with how the redress was delivered, how it was evaluated, and how apologies were provided.
May I add something? I was never offered an apology dealing with the National Redress Scheme. The only reason I got an apology because I decided that I said to my social worker when I went to the police, and I went through criminal proceedings, which was very difficult. I said, I want to help people. So after my court case, I did a story with the local newspaper on the Northern Rivers and the Northern Star, and it was through my public advocacy that I'll go back a bit. So my perpetrator was a science school teacher, as I said, from Benalbo Central School. So that was the compensation was to come from the Department of Education, New South Wales. The Department of Education, New South Wales, they heard my story, and I received a letter from them, and I looked at it and I thought, I thought I'd done something wrong. You know, obviously I thought, oh my goodness, I'm in trouble now. But I read the letter and they offered me, I have to say, a very sincere apology. They flew me down to Sydney and my cousin as a support person. That part of it was very sincere, and I took that as heartfelt sincerity. But that was through my own efforts. It had absolutely nothing to do with the National Redress Scheme, and I'm in a similar situation to Sandra. I was so ashamed of myself, and I thought I lived for 24 years with the dark secret, that dirty dark secret that I had done something really bad. I'm of that age. Oh my goodness, I'm sorry. I've lost my train of thought. Yeah.
Take a deep breath.
Yeah. I'm sorry.
Dean, did you...
No, thank you very, very much for that. That was all very, very compelling. And again, thank you very much for the courage that you've shown in participating today.
Thank you.
Renee, did you have any questions?
I just wanted to say just how thankful I am for all of you for coming today, for being so brave and sharing what you've experienced. And on top of that, you know, it's clear the reflection that you've put into this and the processes and your commitment to wanting this to be better for other people. I just really want to acknowledge that and say thank you. And in the interest of time, I won't ask any questions, but you've also been very thorough in your responses, and I'm just so thankful for that.
Excuse me, Renee, I just have a request. Can I see your face, please, to make it feel a bit more personal?
Just a moment. Yes, absolutely. I've got a bit of wild hair, so I'm terribly sorry.
I don't care about your hair. Thank you.
A very genuine thank you to you all.
Mate, I've realised what I was going to say. Similar to Sandra, I was so ashamed of myself. The plans that I had plans in my life. I went out west working as a stockman, and I was 20 years of age when I hurt my back working as a stockman. I've recently had recovering from a 7-hour back surgery. So my illness and injury has been lifelong. I've been on a pension my entire... I actually work for the Parliamentary Construction Authority building this Parliament House. So from the age of 23, 24, I was on the pension. I've never married. These are the impacts. I've never married. I haven't got children. And as you get older, that's a great sadness. It's a great sadness to carry, you know. And as I was flying down here, there was a young couple in front of me with a little boy, and he looked back at me, and it was just so beautiful. And I realised people realise what they've lost, you know, and I haven't got that. And I've got good friends who've got children, and I love the children, but that's one of the massive impacts that happens to so many people. And as I said, to be offered such a pathetic amount with the redress, where is the justice? There was no justice there.
It breaks you, and you just don't recover.
Is it okay if I say something?
Yes, and then I've got a question for Janine and Lucy. Yes, go LJ.
I know that whatever happens with the scheme, you know, it ends or it doesn't end, but I'd like the committee to think about the kids being abused in institutions now. What happens to them? Do we just have another redress scheme in 50 years? Because kids are still being abused in systems now, in institutions now, just as they were then. And I hope that whatever happens is learnt from them, because those kids will be funneled into the civil court system, which is a violent, horrendous, horrible place. And Aboriginal children who are being abused in care now, they often don't get civil court, they get prison. They get death by misadventure. And we need to think about what this looks like for future planning. And I know youth all of you might not have the ability to enact that, but we have to think about the Royal Commission and what it stood for. Things haven't changed. Actually, in many cases, they've gotten worse. So we're going to have generations of children to come who will require, rightfully so, some form of compensation from the institutions that have harmed them. And I hope whatever happens here, we think about those kids as well, because the abuse hasn't ended with us. It's multi-generational, and not just for Aboriginal kids, for any child who is enacting in any institutions. We know that from Tasmania. We know that from out-of-home care. And these kids won't probably be eligible for the scheme before it ends.
Thank you. Janine and Lucy, just a question. How long have you been in your roles since the beginning of the redress scheme?
So the National Centre was formed in 2021 as a response of the Royal Commission.
Yep.
And it was established for 5 years. So I've been in the role for just over 12 months. So I wasn't here during the redress, when the redress scheme started, or for the duration of it, but been here for 12 months. And Lucy?
Just under 12 months.
Right. I suppose, one of the interests I have at the moment, based on your stories, is what's improved and what's gotten worse with regards to the National Redress Scheme, because I know there has been a number of inquiries where there has been the implementation of recommendations and adjustments, and particularly from what I can gather, Dean's been around a lot longer than I have on this committee, but there is a question mark because some of the things that we've heard about from you, there has been attention given to them. And I was just, my question is, what has improved and what's got worse? Is part of the...
Yeah, we can take that on notice and talk to the team who did the work with people with lived experience of the redress process. And Lucy, you may not have... you may have an answer now.
I think we can take it on notice and come back to you, absolutely.
And one of the other questions that I have been asking everyone that's been here today is, your top line recommendations, and you did note some before, and I've got resourcing redress support services was one of them, extending the scheme for those that aren't ready yet. Planning now for what next after the scheme ends in terms of ongoing support to survivors. Then there was a conversation around the burden of proof around there. But is there anything else that really stands out?
Can I say something?
Yes, of course you can, Sandra.
Thank you. I guess I come back to my opening statement about familial incest, child sexual abuse, how the duration and the type of CSA and torture, how it affects people's lives, and how that really needs to be taken into consideration. It's a very hard thing, because whether it happened 3 times or 300, it still has a very big effect on people. And I guess I'm thinking here, well, I'm talking about myself, that I know when I die, that will be when my struggle with my CSA situation concludes. And I also think of my daughter, who has seen some of the really challenging trauma that I have been through, and the effects on children of survivors and their families in general. I'm feeling a lot in my heart, and I'm struggling a lot to find words. But I just feel there could be a broader scope, and people are, you know, to be believed. As I said, I've been in therapy for decades, and I can pull out a lot of proof that I'm not making up stories, and so I think I'll just leave it there. Thank you.
Thanks, Sandra.
Could I, touching on what Sandra said, I was 14 when it started, and it almost cost me my life, almost destroyed me. But the point I want to make, and I think LJ touched on it, is I'm lucky in that I have a wonderful young psychologist, and to me it is imperative that people have the ability to get health care, and that it's ongoing. I apply for the mental health plan to see my psychologist, and I know that's limited to so many times a year, but I'm 66 years of age and I still see a psychologist. And as many people know, I still get triggers. I still suffer those things, you know, and I don't get up in the morning and think, woe is me, but it is there, you know. So my question would be the understanding how people need healthcare, ongoing healthcare.
Yep. For their lifespan and their changing needs.
And I would say that Robbie and Sandra have leapt right into where I would highlight one of our recommendations, and that is recommendation 9, which is about the importance in having lifespan supports. And there is no, I wouldn't say that. There's a very fragmented system at the moment that was identified through the Royal Commission for supports for victim survivors, and there is an enormous amount of work that needs to be done in ensuring that we have a nationally consistent lifespan support program that can operate in the event that the redress scheme concludes. Ensuring access to free trauma responsive, culturally sensitive supports, as Robbie said, across health and a range of other support services. There's always going to be a need for legal supports, transitioning across supports, and supports that arise at different points in people's life during their lifetime are critical, and that doesn't happen in a planned way. So it's known that we need those supports. And at the moment, it's incredibly fragmented. It makes it very difficult. And I think that LJ, Sandra and Robbie have really clearly articulated the impacts of not having that support available across multiple service systems in a streamlined, coordinated way.
Child sexual abuse is a public health issue and it needs to be funded as such. You know, in Victoria, through the CARSs, you get 20 free sessions. That's it. Most people rely on the public health system or the private system, and if we know that child sexual abuse affects your ability to engage in the workforce, in education, it has economical costs due to the impacts of trauma, then there needs to be a public health approach to lifespan supports, but what that looks like, because it can impact a person's life in every aspect. So there must be consistent services that are funded to support someone ongoing. And there needs to be consistent support and support that specialises for different groups, especially marginalised groups.
Can I just quickly...
Yes, and then we'll need to finish up.
Thank you. At this point, I was still working with the National Redress Scheme. My application was in, and as I said, it was a public school, the New South Wales Department of Education. When I contacted them, their lawyer, and I said, you know, I need healthcare, and I was very bluntly told, well, go to the mental health plan. I was wiped from that, so I just want to make that point. Thank you very much.
Thanks, Robbie. Dean, did you have any other questions or comments?
Nothing further from me. Thank you very much.
I want to thank you all for presenting today, and yeah, as we've said and Dean said, your courage and determination in being here and advocating for yourselves and also other survivors. So thank you. You will be sent a copy of the transcript of your evidence and will have the opportunity to request corrections to the transcription errors. Please send your responses to any questions taken on notice during this hearing to the Secretariat by the time that the Secretariat will advise. And yes, just thank you all very much for being here today, and I hope you're okay after this session. Obviously, you've got Lucy and Janine there, and you've got each other, so that's a good thing.
Thank you very much.
Thank you. Thanks for listening
Yes.
and inviting us. I appreciate
Pleasure.
it.
Pleasure's not the right word, but yeah, thank you.
Suspend.
Oh, and the committee will suspend the proceedings. Dean, are you there? I can see you're on mute.
Yes, I'm here. Yep.
Beautiful, thank you. Well, I'll just take the opportunity to have us introduce ourselves. As you know, I'm Jodie. I'm the federal member for Dunkley and in Victoria and the chair. And I will throw over to Dean, who's behind me, but in front of me as well. Dean, would you like to introduce yourself? Oh, we've lost you. Oh, there you are.
Yes, there we are. Good afternoon, I think, where you are. My name's Dean Smith, a Liberal Senator from Western Australia and the Deputy Chair of the committee.
Richard?
Thanks, Chair. Senator Richard Dowling, Senator for Tasmania.
So now I will welcome everyone here. Oh, whoops, I've got the wrong page. Welcome everyone from No More Legal Service to give evidence today. For the benefit of Hansard, would you please state your full name and the capacity in which you appear before the committee?
I'm Jackie Mead, I'm the CEO of No More Legal Service.
I'm Sean Bowes, I'm the Manager of Advocacy and Law Reform at No More Legal Service.
I'm Gary Oliver, I'm the Executive Director of Strategy and First Nations Engagement.
And Rachel Neal, I'm the Executive Director of Integrated Services.
Well, welcome to all of you and thank you for submitting your submission. The hearing is a legal proceeding of Parliament and it has the same standing as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Do you wish to make an opening statement?
I do. First, I'd like to acknowledge the Ngunnawal people upon whose lands we are gathering today. I pay respects to Elders past and present, and I would also like to acknowledge any First Nations people within the room and my First Nations colleagues throughout No More who share their knowledge of country and culture with us in the best interests of the many First Nations people that we support. No More is the only national independent legal service dedicated to survivors engaging with the National Redress Scheme. And we're embedded in the system every day across every jurisdiction. We work alongside survivors, and I would like to acknowledge the survivors who've given evidence as part of your recent proceedings and acknowledge the importance of their contributions. We also walk alongside redress support services and the scheme itself. It gives us a really unique vantage point because we live in the world where policy intention meets lived reality, where the delays and inconsistency and distress actually play out and impact on the lives of vulnerable people. Our submission reflects this. It reflects the aggregated frontline experience. It reflects the patterns that we see across thousands of matters, and it acknowledges that they're not isolated cases that we speak about, but systemic trends and things that must be addressed. The National Redress Scheme has delivered meaningful outcomes for many survivors. For many, it has been life-changing, and that's what makes what happens next even more important. We acknowledge that there are survivors who don't feel that the scheme has met their needs, and I think it's fair to say that any scheme of this size will always have places where improvements can be made. But the reality is that we're now entering the final phase of the scheme, and it is absolutely critical that it ends well. The core problem that the scheme is facing is that time's running out. We have our legislated deadlines with applications closing 30 June 2027 and the scheme ending 1 July 2028. And the numbers, the sheer numbers, matter because the Royal Commission estimated 60,000 eligible survivors. Only around 1/3 have received payments so far, and their backlog exceeds 43,000 applications. The sheer numbers indicate problems. Those problems, I guess, exist as average processing times now sitting at over 17 months in our experience, and internal reviews often adding years to that kind of time frame. We're also seeing application numbers increase year on year. And a surge before the deadline isn't hypothetical anymore, it's well expected. So without decisive action, thousands are going to miss out entirely, and thousands more are going to be re-traumatised by the process of trying to decide if they're going to do this or not. Therefore, extension to the scheme seems to be the best answer, and we certainly agree that it's the neatest. We therefore recommend extension of the scheme and remind the JSC that the Royal Commission recommended no end date for the scheme, that in fact a scheme like this should continue in perpetuity until there are no victims. We consider that despite the costs of the scheme, the likely costs for institutions, including jurisdictions at a state level, when they conclude the scheme, will be high. They will be at least as high as they are currently. And we know that the cost of the scheme is a core reason that institutions are concerned about extension of the scheme. Understanding the numbers that sit behind these concerns is something that I think is going to be very important to be considered as part of the 8-year review. That being said, we understand that there is a very strong possibility that the scheme cannot be extended. And if that is the case, then we must change course. We have to confront this as a realistic possibility, and we need to understand that if we stay on the course we are currently, then the trajectory will fail. The scheme's already under extreme pressure, escalating application numbers, long processing times, and rising survivor anxiety. Doing more of the same in the final year will only result in poor and non-trauma informed outcomes. Therefore, a course correction is required. We need to take on a different approach for the next 12 months. And the priority must be getting applications started, not completed. This requires a deliberate shift with the focus on lodging minimal threshold applications with sufficient enough to engage the scheme, but with the details of the assessment being captured later. This means that we don't need to change the date that applications close, but we extend the period for processing applications by a significant enough time to ensure that the process can be both trauma-informed and effective in the support for survivors. For either of these things to happen, though, awareness and access to the scheme have to increase, and they have to increase urgently. We find it astounding that so many people still come to us who had no idea that the scheme exists. Clear, trauma-informed public information with targeting advertising campaigns is critical if we are going to be able to draw this scheme to a conclusion at any point. This is especially critical for First Nations survivors, for people with disabilities, for people in prison, and people living regionally and remotely. We also need to ensure that fairness and consistency continue throughout these final stages of the scheme. We continue to see systemic problems, inconsistency in decision-making, a lack of transparency and uneven survivor experience. But I do think it is important to acknowledge that we have seen recent changes in staffing within DSS, and these changes have given us some cautious optimism. We want to acknowledge that recent engagement with the Redress Support Services and with the Department of Social Services and the scheme have been constructive, candid and encouraging. There's clear acknowledgement by the department that inconsistencies exist and that the survivor experience has been variable in an unfair way. That gives us a foundation to build on. We remain concerned about the recognition of certain forms of abuse, including grooming, but this isn't our central focus for today. Our priority is around system-wide fairness, clarity and trustworthiness in the scheme's final phases, and these are the themes that must be addressed in any advertising campaigns or promotion campaigns that are used. Beyond the scheme, though, survivors are going to need support. Regardless of how the scheme ends, survivors' legal and justice needs do not end with it. After the scheme, survivors will still need help to navigate options about civil litigation, class actions, reparations schemes and state-based responses. And without ongoing legal support, survivors are going to be left to navigate complex systems alone and be exposed to exploitation, neither of which sit with the apology that our Australian government made. There's a clear ongoing role for free, independent, trauma-informed legal assistance for all victims of child sexual abuse. And planning for after the scheme needs to happen now. It's not an afterthought. It's essential to honour the promise that was made to survivors by the Royal Commission and by our Australian government. And the way to do that is by providing them with clear information around what exists beyond the scheme. It is the only information that helps them make an appropriate decision around whether coming forward for redress is the best option for them at this point in time. We also have to consider the survivors who are ineligible because their abuse occurred after 2018. This is actually a growing group of survivors, and extension to the scheme has a significant impact. It's critical that we begin to think about this cohort of survivors, and we believe that we will essentially need to operate two models of support. One that exists beyond the scheme but begins when applications close and covers all of those people post-2018, and one that exists beyond the scheme, and one that sees current applications through to the completion of the process. We are at a genuine crossroads. If the scheme can't be extended, it must evolve. The worst outcome is doing nothing different and watching survivors fall away at the end. We urge the committee to support a changed course of action in the final phase, early accessible applications with realistic planning and a future beyond the scheme. And we stand ready to work with government, the scheme and support services. We believe it's a shared task and it's simple but profound. All of our jobs is to ensure that we do not let time erase justice.
Thank you so much, Jackie. That was very thorough, as is everything that you produce and give to us, so thank you very much for your submission today. We've got a range of questions and I've just was writing notes. Look, there's a question, I'm just going to kick this off. You know, we've been listening to lots of people that have submitted submissions to the inquiry, and my question for you to begin with, do you think the scheme has improved or gotten worse? That's a very clumsy way of saying it. But
if you had have asked us 3 months ago, we would have said that the scheme was significantly worse than we'd ever seen it before. Our staff would have said the same. People are finding it very difficult because, in fact, the number of ineligible outcomes was reaching a point where people were losing faith in what the system could deliver.
I heard that with Zoe when we came and met you.
What I can say though is that this year, the last 3 months, as I said in my opening statement, has given us some faith.
So what's changed?
The leadership involved in the scheme and key staff. Their recent engagement with the redress support services across the country was powerful and important, and it stood as a point in time of bringing people together on the path towards the end of the scheme. It acknowledged past outcomes weren't great and it gave us pathways, I guess, to escalate concerns that we have. So we remain cautiously optimistic that we will see improvement. We felt that there was good response to the Productivity Commission recommendations, and there was acknowledgement of the failures that particular process had identified.
Now, just before I go on and ask the next question, David and Renee, would you like, and Richard, you've introduced yourself. Yeah. David and Renee, would you like to introduce yourselves?
Hello, I'm Renee Coffey. I'm the federal member for Griffith in Brisbane. Sorry for being a little late.
Oh yeah, I'm David Shoebridge.
Green Senator from New South Wales, and it's good to see you all. Thanks for your evidence as always.
What improvements have you seen so far? I know there's been IDMs, the independent decision makers. That was part of the conversation that we had when we met with you in Melbourne. So let's start there.
It'd be fair to say that we're not sure that there is consistency across the IDMs at the moment, but we've seen some. Rachel, I don't know if you want to speak to this particularly, but we have seen some outcomes come through that feel like the standard has moved more towards a reasonable standard of proof again.
But improved. There's still inconsistencies there. I think the willingness of the department to engage with services to talk about, for example, the language that is used by IDMs in decisions. This is a very recent thing, but that shows that willingness is hopeful. Whether we're seeing that filtered down in a day-to-day sense is another question, but we're certainly seeing that. The implementation of we hope to get more information about the chief IDMs and how that works. There was some discussion of that at the RSS forum that was on the Gold Coast a couple of weeks ago. And we've also heard that they're employing more IDMs, so that is an improvement in itself to try and get outcomes out more quickly.
So I'm just going to go backwards a bit, and Dean, you might be about to ask this question. It's about the ANAO's audit report. What's your response to receiving that? What did you think of the feedback?
Do you want to take that one, Sean?
Bless you, Dean.
The most significant aspect of the report was that it found that the administration of the scheme was only partly effective, and we said quite bluntly at the time that, in our view, partly effective isn't good enough when it comes to a scheme of this nature. So that report is a really valuable wake-up call, and I think it links to the course correction that Jackie was speaking to in her opening comments. We've got quite a rigorous report now from a body such as the Auditor's Office highlighting that there's some pretty serious issues here, and we're hopeful that further discussions with the department are going to lead to some progress there.
In particular, the implementation of quality framework, which was one of the things that was found to not have been appropriately implemented, appears to give the department a greater capacity to manage the quality of the outcomes and the work of not just the IDMs, but I guess the scheme in general.
S24 letters, we had a bit of a conversation about that when we met. What are you seeing in that space? We've heard some examples over the last couple of hearings about them being, some examples of them being not appropriate. You would have experience of seeing a number of them. What's your thoughts on the S24s?
Yeah, we've certainly seen some where the language isn't appropriate. We've seen direct quotes from the institution be put into the letter in relation to the applicant's claim, and that can be very distressing and usually wouldn't happen even in a civil claim. That would be filtered, I guess, through lawyers, whereas it's directly in a letter that's sent to the person. I guess the other issue that we're seeing is that people are given a set amount of time, 4 weeks, to respond, and it's impossible to get advice or assistance from either us or a redress support service in that time frame. And so it's essential that people get advice so they know how to respond, and that can take time. So we're seeing people either not getting extensions or having to seek several extensions just to get them to the stage of having an appointment with us. So our appointments at the moment are around 7 weeks delay to get an appointment. We've explored with RSS as to whether we are better off to refer them straight to an RSS for assistance with that, but a lot of those responses have been it's not really much different with us because of the delays that they have as well and the wait lists that they've got. I guess the other S24 issue that we're seeing is where the quality assurance issue comes up in those, where there's basically we don't believe you because there are several other applicants who have applied, and we just consider that to be incredibly inappropriate and distressing for survivors to be told that they're not believed. And we also know that perpetrators in institutions have very similar modus operandi, and it's not, yes, within the realms of possibility completely that the description of abuse is going to be quite similar. The other thing we've seen come out of the S24s is a request for really specific details about the abuse that we haven't seen before. Details about what time of day did it happen. Yeah, detail that we don't consider fits within the standard of proof that applies in this scheme.
Dean, have you got a question?
Yes, I do actually. Thank you very much for your participation today and for the important work that you do for survivors. We've heard some evidence earlier today about the lack of take-up in regards to direct personal responses. I don't know if you heard that evidence, but whether or not you might have any observations to make about the utilisation and the utility of the direct personal response, because it's always been assumed that this was such an important and powerful element in the in the redress process, but also in the healing experience of people. And I was surprised to hear some of the comments about the utilisation of the direct personal response. I forget now whether it was the Catholic Church or whether it was the Roman Catholic Church or whether it was the Anglican Church that made those comments. But any observations that you would make?
So we've known from the start of the scheme, from scheme data, that the uptake of the response has been low. They did establish a branch of the scheme that helps to facilitate the DPRs. I think that some issues that arise, one is that some applicants feel that it shouldn't be on them to contact the institution themselves, given that the institution is the body that caused them harm and they have issues with that. We've also had several people talk to us about the response they've had from certain institutions that has been really insufficient, and that they haven't felt it was a genuine apology, that there haven't been enough work put into that apology process by the institutions. It's a bit of a mystery to us, but I think those are some things that we've seen, and not just recently, but over the years. The department putting in place a branch, I guess, or a group that can help to facilitate, I would have thought would have helped the uptake. But we do know that survivors talk to each other, and that it may be that the negative experiences that people have had has impacted that uptake. Having said that, I've had several clients who have accessed their DPR and they have found it life-changing. They have found it really powerful. And I think it's a real shame that we're not seeing a bigger uptake where people are having that really positive experience. And, yeah, that healing journey it's really helped them on that healing journey.
So it is a matter you believe does deserve sort of a level of attention even this late in the scheme's operation?
I think that it's particularly important at this stage because people aren't always ready to access their DPR straight after they have an outcome. and it might take them some time. Certainly one of my clients who it took them some time to actually be ready to go and speak to the institution. And as we get closer to the end and we don't know what's going to happen to the DPRs after the sunset date, I think people may be more reticent to be accessing if they're not sure that they're going to be given the same care. So I do think it's worth attention at this stage particularly, because if people are going to have, people with outcomes are wanting to have that healing process to start, but they're not quite sure when that will be available, and maybe they think I have to do it in the next year or 2 years, they may not be ready to actually take that up at that stage. We know it takes a long time for people to disclose child sexual abuse, but equally from my experience and our practice experience, it can take people a long time to take that extra step to speak directly to the institution that harmed them.
Senator Smith,
thank you for that.
Sorry, Senator Smith, can I just add to that as well? We are aware that a lived experience or a lived expertise position has just been put into that DPR team, and we think that that is an incredibly important step towards ensuring that there is greater uptake. We hope that it will in some ways address the social media chatter, etc., within survivor groups that is discouraging people to come forward.
In your earlier remarks, you characterised some of the personnel changes in the scheme as cautiously optimistic. At what future point do you know if your cautious optimism is justified or has been justified or has not been justified? So I'm keen to understand what is the time frame that you are consciously giving the scheme in terms of whether or not it has genuinely learnt and responded to the findings of the Audit Office inquiry and your trust in that new personnel which seems to have now sit over the operation of the scheme. What is the time frame in which you think it's fair?
Senator Smith, we're expecting to see, I guess, active and continued work with us on the solutions over the next 2 months. If that doesn't happen, then I think that our optimism would significantly reduce. But we think within 2 months there is such a long list of actions that were agreed out of several meetings that if those things aren't progressing and progressing rapidly, and if there doesn't continue to be open discourse about possible solutions that we can come together on, rather than, the RSSs and us working on one side and the department working on the other, then we will know that in fact we're in a dire situation.
How often Sorry, you go, Dean.
So the active and continued work, as you call it, is that a formal structure that you're working in and with the department on?
Okay, so there's a couple of things within it. Out of that RSS forum that was held in Brisbane, on the Gold Coast, a long action list came out of things that needed to happen and need to happen rapidly. Everyone is well aware of the timeframes on this. Rachel spoke to one of them around the establishment of a group to talk about more appropriate trauma-informed language. We already know that group has been, that times are being set for that group to meet, and that it's happening quite quickly. We consider that to be a first step, I guess, of good faith. So there are some kind of formal groups that are coming together. We meet with the department, I guess, at an operational level, which might be to talk about a particular case, or it might be to talk about the rub that we're having between two parts of the system.
That's every 3 weeks. We have that operational meeting, and then we have a fortnightly meeting to talk about specific delays with clients.
And on top of that, the DSS executive, so the people that are leading the scheme, are meeting with our executive on a 6-month or quarterly basis, just depending on what we have. And that is more about the problem-solving capacity, what we can bring to the table and what they can bring to the table to try and find some solutions.
So, Jackie, are those meetings, is there an increase in the number of meetings you're now having with the department?
Up until for the last 2 years, there wasn't a schedule of meetings. There wasn't a capacity. We felt like we were beating down the doors to even get attention on these issues, which is one of the reasons that the JSC became so critical, because it was one of the few ways that we actually had to highlight and raise issues. But we now believe that there is a relationship where we can address them in the way that it always should have been. And the way that it was when the scheme was initially set up.
We're seeing improved lines of communication as well. So
Yes.
in the past, we've been absolutely unable to communicate by email with the scheme, but we now have referrals coming in from prisons by email. Documents for the scheme are being sent by email, and it just speeds things up greatly. We also have a better line of communication to particular officers within the department, whether that's giving them a call or emailing them, and we get faster response times.
Dean?
And just for clarification, by JSC, you mean the Joint Standing Committee of the Parliament, which is this committee that you're appearing for before today?
That's correct, Senator Smith. And I guess in terms of, I was referring to the previous version of this committee in terms of the past period over the last 2 years.
Yeah. So final question before others. How realistic do you think it is to be talking about scheme extension as opposed to scheme closure? It's first question. Second question, if we are talking about scheme closure, should we be starting to identify and address those, what would be in insurance called sort of long tail issues, right? Like a direct personal apology, so that we have not an alternative scheme, but we have scheme closure, but we still have a structure, a mechanism that properly affords people the dignity of their application, the resolution of their application, the various things that stem from that, rather than an abrupt end. Do you understand the point that I'm trying to make?
I do, Senator, and we certainly that is exactly what the evidence from other countries shows us. The fear and the distress that is caused by a sharp end is re-traumatising in every way, and to know that those support services, so access to counselling is another one, as well as the DPRs, that those things remain available arguably forever. Well, certainly for the life of the survivor, because they are just that important in their healing journey. You also asked, if I go back to the start of your question, around, I guess, the likelihood of extension or our views around that. We have to advocate for scheme extension if we are going to honour the voices of people with lived experience. That is what they're telling us is necessary and needed. But as, I guess, somebody who's worked within this system and similar systems for a long period of time, we have grave concerns about the ability of that to be delivered. And that's why we've also put our mind to, well, if not that, what is the second best option?
Thank you.
But survivors are very clear in their desire for scheme extension. Sorry, Sean.
No.
And just to clarify the scheme extension, so we have a hard close.
Application date.
Yeah, so we've got a hard close of applications by the 30th of June 2027, and then we've got
12 months.
12 months to get through those applications. They're advocating for an extension beyond 2028 to be able to complete the applications.
They're advocating for extension of the application date. So they are saying they need more time to be able to put in their applications, and more time is required for survivors to come forward and seek justice.
I was going to make precisely the same distinction that the Chair's just made between the deadline for applications and the end of the scheme itself. Our position as an organisation is that what happens with these two dates needs to be driven by evidence and data. It's too important just to pick an end date out of thin air. And at the moment we have better data in relation to one of those two dates than the other. We have better data in relation to the end of the scheme as a whole, because we have data as to the processing speed of applications that are currently in train. And
do you have that date?
Have date?
Do you have a sense of what that date is that
yes.
you're happy to share with us? Or
yes.
do you want to take that on notice?
So, well, it's not so much a date that we're happy with as where the scheme's currently heading.
Yes, yeah,
because
absolutely.
with the most recent analysis that we've done, the scheme is going to need until October 2038 in order to get through all of the applications that are anticipated to be received. So that's based on the government actuary saying there's about 90,000 applications that will be received. And with the processing times for 2024 to 2025, that's how long it's going to take the scheme. So it's quite clear that the scheme is not just a little out of sync with the timeline that's needed, it's majorly out of sync. And we do acknowledge that the scheme has its own resourcing restrictions to contend with. Our perspective is that this needs attention from the government to ensure that it works for victims and survivors.
Renee, you've got your hand up. And then David.
Thank you. Thank you so much, Chair. And thank you for everything you've shared so far. I'm just wanting to understand, based off the assumption that the scheme will end in the timeline that's been outlined, what do you think the challenge is in terms of reaching, in particular, vulnerable communities with awareness about the scheme? How well you think that's happened to date? I think we've discussed that before, but what would need to happen to reach out to elderly communities, communities with disabilities, languages other than English, First Nations communities, people with poor literacy and mental health, the incarcerated? What do you think that challenge looks like with the current scheme timeframe, and what would be necessary for those communities to receive information about the scheme?
Renee, thank you for that. That brings into front of mind the work that we need to do around incarcerated people as well. We know that incarcerated people were excluded for 7 years of making an application, and they've got 3 years to make an application. Currently in Australia there's 47,000 people that are incarcerated around the country. 13% of those are First Nations peoples across 113 custodial centres as we look forward to. How do we get the information to them? How do we support not only us but the RSSs to make sure that there's a service provision in that space? Because in that space they're not just incarcerated people, they are people from non-English speaking backgrounds. They are people with disabilities, they are people that are aged, and they are people from First Nations as well within that space. So we know that the amendment 2 years ago made provision for them to make application, but there's a lack of information out in these custodial settings. We work across 80 prisons at the moment in doing the work with our prisons teams. And, we know that there's 17,000 First Nations people that are incarcerated. And you look at some of the states where there's high incarceration levels, some of them are from remote areas as well, where English is third or fourth language in the space that they are. The highest incarceration rate, sadly, is in WA, in Western Australia. And we've just heard from the opposition in Western Australia that 40% of those incarcerated are actually on remand. So when they get out of jail, we lose them through the community corrections model as well. So they lose contact with us and they lose contact with their applications as we speak as well. For us as First Nations people, we know that the Close the Gap target 10, is not working for us to reduce the level of incarceration. So we've seen an increase in incarceration by 20% since 2019. So there's been some failures that have been identified through the ABS and through other government reportings. But what does that mean around marketing? How do we market the NRS within those areas as well, not only in hard paper form or electronic form, but also maybe in social media or some ads on TVs. And for a lot of those groups around, I'll call them minority groups, including the First Nations groups, it's got to be eye-to-eye contact. It's got to be seeing people and providing the information to people to form the level of trust that survivors are willing to share their story, which would enable an application to be made. We at No More, we have a Northern Australian strategy that will inform the methodology of how people can work within this space in a culturally competent manner, but also in a trauma-informed manner. And the Northern Australia strategy that we have, even though it's got the word Northern in it, is applicable across all of the sites. And it's about engaging with people, it's about engaging with communities, and it's about having some scoping done, some stakeholder engagement, then some clinical work in communities. And I'll call prison spaces communities as well, because that's what they are in that space. So that three-prong process we have labelled as 1, 2, 3 cup of tea. You know, you be seen in a community, you be acknowledged in a community, then sometimes you're being asked to sit down and have a cup of tea and form that relationship within those spaces as well. The marketing's got to be integral, but there needs to be funds for groups like No More and the RSSs to do face-to-face work on outreach within these spaces, whether it's non-English speaking backgrounds, disability, or the incarcerated spaces and the First Nations communities. I just want to mention, when I talk about the First Nations communities, we over the last 2 years have attended the APY lands on 3 occasions. And we've done the breadth of the APY lands throughout the northern part of South Australia into Western Australia, who still count themselves as the APY lands, and including the service hub for those communities in Alice Springs. We still find, though we've been across those spaces 3 times, that we're meeting new people. There's new opportunities for conversations around the NRS, but there's also a difference in the way that we deliver based on the interpreter services that we have travel with us in this space. So when we talk about marketing, it's not just the language that we need to use there, it is also the culture of the language that we need to use in those spaces as well.
Thank you so much. Chair, I just had one more question. And I should say we've heard from witnesses today very high praise for No More and the work that you're doing in the community, so that should be acknowledged. I also just had a question, and I don't know whether anyone will have something to say on it, but we have heard testimony about high control groups, sometimes known as cults, and how people who have experienced abuse through high control groups have interacted with the redress scheme. I was just wondering if any of you had any insights into that or any experience working with victim survivors who have come out of those high control groups.
I recently just presented to the Victorian Parliament inquiry on this topic, and it's actually become a small area of specialty, I would say, for us as an organisation, largely driven by word of mouth, where we help one survivor and that helps get other survivors out. But our experience has certainly been that it is very, very difficult to get some of these high control groups to be recognised as institutions and therefore for eligibility to be available under the scheme. And that's just heartbreaking, because fundamentally one of the case studies within the Royal Commission was based on high control groups such as this, and the Royal Commission always intended that these groups would be viewed as institutions and fall within the scope of redress.
Jackie, just on that, is that because they've, how do I say this, adjusted their business model so that they don't have the assets?
I don't even think it's necessarily an assets issue. I mean, because
or the finances to be able to
there's some elements of that, but you know, that's where the jurisdictions are meant to step up as a funder of last resort. That's how the scheme was established and what was expected. It's more that the nature of what they do becomes very much tied to family. So the abuse is not necessarily denied in some cases, but it's viewed as intrafamilial rather than institutional. And the reality is that that's where these cult-like institutions are sometimes hiding.
So they're not meeting the criteria of the scheme, therefore they're not
being designated as an institution. So if the abuse happens within your family, but the expectations on your family to treat you in a particular way are as a result of the power of the institution, then how that bit is being viewed is one of the areas of concern.
Can I add the complexity of First Nations communities? We've had advice from a community that we went to in a remote setting that the deacon of the church that committed these offences against children was also the uncle. So that interfamiliar response that there's no eligibility therefore. So that's problematic.
And so the family relationship was deemed the dominant relationship, not the institution.
Yes, yep. So, and then when we have a look at high controlled groups from a First Nations perspective, the dormitories that a lot of our people had suffered through as well is seen as a high controlled group as well. And of course the state owned the responsibilities for those dormitories, and more so for the journey that we had in Cherbourg, listening to the Cherbourg dormitories and the survivors that were there. Some of the survivors hadn't wanted to progress action because what the dormitory meant to them at the time, even though they suffered as a survivor as well. So.
David, do you have some questions?
Yeah, I do, thanks, Chair. And sorry, I was unavoidably jammed earlier this morning. Thanks to No More, thanks for your evidence and all the work you do. I suppose I just want to ask, first of all, about the pressures on No More, what your budget is, what the rejections are, and what your client numbers and file numbers are. Can you give us some insight into that?
Yeah, we're budgeted for a 63% reduction in grant funding at the end of this financial year, and we are still seeing increases in client numbers. Our last 6-month reporting to the department showed an increase in service delivery yet again with the same resources being used. And it just can't really stretch much further, Senator. There is only so much that can be done, and Rachel talked earlier about a 7-week wait list. I think that we would all hope that there was no wait list whatsoever, but we can't stretch our people any further than they currently are. One of the other things that I guess is happening more often and that we hope we'll see some changes around is the amount of time and energy that we're needing to spend on reviews and revocations. So the claims that we really think should have gone through and haven't. And obviously those things take even further effort and further time, which means that we're not then able to pick up that extra incoming waitlisted work. It's untenable in the longer term, it's difficult to keep morale high for our staff, when they're working under these conditions. That being said, we know that it is the same across the redress support services, and we know that it's the same within the actual scheme itself. And part of the problem is there's nowhere to shuffle this for any of us, because everybody is facing the same resourcing shortages. We know that it's going to be a very tight fiscal scenario. We're all watching the prices of petrol. We know where government's attention is and where it needs to be. But this is going to be an ongoing problem, and if we wish for the scheme to operate in the way that it had always been intended, then additional funds are going to be required right across the workplace, right across the sector.
So if you
you've seen not only case numbers go up, but the complexity of the cases increase because you're having to do more reviews and reassessment applications. So that's been kind of a double hit to you this year.
It has, yes.
So I just want to clarify something. So there was some additional funding given, $22 million that was given end of last year, I think, to services to deal with the load. Is that correct?
We certainly received some additional funds, yes. And interestingly, the place we didn't receive additional funds was to provide support to the RSSs, or we didn't receive appropriate additional funds to provide the capability development support to the RSSs. And obviously the prisons, the sheer demand coming through from the prisons completely overwhelms us. We visited one prison in Western Australia, and I think there was more than 50 applications that came out of that. To just process through that amount of applications in a prison setting where we can only get appointments on certain days and they are only staffed to support a process like this, you know, under certain circumstances, it's incredible. We actually had to put a halt on things at that point and deal with that wait list before we could reopen to, you know, new prisons and new people who need our help and support.
So I just want to understand, so you're talking about a 63% reduction at the end of 25-26. Is that because of the increase in numbers?
No, it's because of the original...
Or is that the budgeting for the term of the contract?
Yeah, it's the original... like, if you're asking me, do I think we'll receive a 63% reduction? I hope not, because essentially that would decimate the work that we're doing. But because the funding agreement is based on the original actuarial studies that said the numbers were going to drop off as the scheme continued... our funding agreement says that we reduce
so it's how it's
dramatically.
been. But over the period of your funding agreement, you have received from previous conversations
significant top-ups. Yes.
So my question
But if you're asking me, would another 22 million be enough? If we just continue as we are with the same funding we received last year, we will see increased wait lists because the number of applicants is going up as well.
Yeah.
Yes,
go, David.
Importantly, like that's 53 days away, and that's what you're being told at the moment is your funding envelope. You've got staff that you want to retain, you've got services you want to retain, you've got to be planning for this. You need certainty if that number's going to be wrong and the funding's going to be what it needs to be, which is significantly more. You need that certainty pretty much now, don't you? You can't wait until another 4 or 5 weeks. Staff and your service.
Yeah, it's ideally a variation to the contract, not year by year, but for the rest of the potential life of the scheme would be incredibly helpful. We've just been through the same scenario with the Territory Stolen Generation scheme because our funding for that drops dramatically. That just got a 1 year extension last year and saw a dramatic reduction in potential funds. And Christmas this year, we lost a substantial number of staff because there's not security for them. So we know the same pattern will occur for this scheme as well.
Did you put a budget request? Have you spoken to the department and did you put a budget proposal?
So there's a couple of budget proposals that we put in. The first one is that we asked for an extra $5.3 million to support prisons across Australia. We know that they gave additional funds to the RSSs to do that work, but the reality is that there are legal complexities that sit in this work, and when the RSSs go in, all that happens is their support that they need from us dramatically increases as well in a lot of instances. We have significant experience in this place, and we felt that it made sense to kind of centralise it, use that legal experience and create that as a nationwide response that would allow us to get through all of the prisons in the time that was available to us. So that was one of the things that we asked for. With regards to budget submissions specifically for this year, we have had ongoing conversations regarding the funding that's necessary for this, and we understand that it's under consideration, but yeah, the timing is always difficult. I'm more worried though about the timing for 2027, the next year, because that's going to see a huge drop.
12 months from, unless something changes, it'll be the 8th of April, and there'll be 53 days before the scheme closes for applications. That is going to be a disaster zone for survivors, a disaster zone for your services and other services like you, with a sort of grossly unfair, unseemly rush to throw anything in the system that you possibly can. What can we do to avoid that? What do you think the key steps are to avoid that horror show turning up in 12 months from now?
Senator, we think it's critical that the government is able to say what will exist after the scheme. And what we think needs to exist after the scheme is a national legal service funded at around $22 million that supports all victims of child sexual abuse. So forget about redress, whether it comes through redress, forget about whether it's non-institutional. Survivors don't care or know. They just know that something awful happened to them and they need help and support to navigate the way through it. And that's what we think is necessary. And we think that if that type of announcement can be made, then survivors can decide, do they want to go through the redress scheme as it currently stands? And if they don't, there is another option available to them. It takes the pressure out of it. And certainly, again, that's what survivors in other countries have suggested is necessary, that they know what exists after the scheme.
But I've also seen projections that suggest that business as usual, following the trend that we're seeing in decisions being made, in applications being launched, the business as usual scenario sees potentially 50,000 claims that are in the system by the middle of next year when applications close, and then only 12 months to decide 50,000 claims under the statutory timeframe. Now that would break the current redress system, fundamentally break it.
And
have you been looking at what those projections yourself?
Yeah, and we certainly know that to process everything that's going through the system, if resources stayed the same within the redress scheme itself, so IDMs, etc., stayed the same, if there's no increase in those numbers, it'll take them to 2038 to be able to get through everything.
But the scheme just shuts in 2028, not 38, 28.
That's right. So we're saying that even if they don't move the date of application closure, the scheme closure will need to be 10 years after that.
Well, I mean, that would be a grossly unjust system for everybody if it took us 10 years to digest claims that were lodged in up to the middle of 2027. There needs obviously to be a multi-pronged response to this, working with institutions about extending deadlines, working with the department and the government to increase resources, and working with the existing resources to make sure they're as efficient and survivor-focused as possible. I think it's going to be multiple strings to this, do you think?
Absolutely. And, that also brings into play, Senator, the people who haven't been eligible for redress from 2018 because they're not eligible for the scheme because their abuse occurred after 2018. How long do we expect those people to sit with no options of support other than to approach an institution who's not that interested because they're doing redress? We have to think about those people as well, because they're our care leavers and the kids coming through youth justice right now.
And my final question, Chair, is I think you said you've been to the YP, I'm sort of forgetting.
APY lands?
APY lands. So you've been to the APY lands in South Australia on 3 separate occasions. And each time you go, you find a new cohort of survivors. My assumption is that as you're doing this, you're sort of reaching out into more and more vulnerable and harder to reach survivors. And that may well be the pattern across the scheme. These last few years are reaching more and more vulnerable and hard to reach survivors. Therefore, they're more resource intensive patients. But also it says to me that ones we don't get to by the end of next financial year are going to be the most marginalised who are going to be left out. That's a fear I have. I don't know what your experience suggests.
That's the fear that I have. Kugialanji from up in Cape York. You know, not many of our communities there know or accept the language that we use as part of the NRS. We can't talk about child sexual assault in that form of language in the Cape and also in the Northern Territory, because it brings to people's mind the intervention. That's what it brings to people's mind. So through the NLC, we've been told to use different language when we engage with communities, and that's around nighttime business or bad touching, no good touching. Those are the type of language sets that we've been asked to use, and in using them, that has brought out survivors to us. But if we go in there and use the language of child sexual assault, they think the army's coming in, the communities are going to close, and our assets will be stolen from us again. That's what happened through the last intervention. So we need to be mindful of that. And of course, you know, we hear the hot spots of Aboriginal communities like Wadeye and the servicing of Wadeye and the federal government wanting us to be in Wadeye and do work. But there are smaller communities as well that we need to get to and market the NRS to and have engagement through our Aboriginal engagement advisors leading our lawyers and our social workers and our financial counsellors. Some of the great work that we've done with our financial counsellor in Wadeye, for example, we've used a financial counsellor from Adelaide who's now been nicknamed by the community as the money man, because he sits down and has conversations with family groups, not just the applicant, but actually family groups. And much to his excitement, last year he had a child named after him as well in the community. So that's forming a relationship. That's not just a service model, that's a relationship that our FC in Adelaide, Tom, will have with the community, that if he went back in 10 years, they'll know him, or they'll know the story of him. And as you know, a lot of our history is developed through verbal history within the framework. But, you know, if we get to Murujulu, if we get to other areas, we need to form those relationships. We need to market things in localised language, Pitjantjatjara language, Kugialanji language, in TI language, and we need to do it better. But I'm in no doubt we need more time to do it. And if it brings just one more applicant, that's a success. You know, the department may say it's got to be numbers driven and we've got to have, you know, 10 applicants a week or something like that, but to bring one forward and that one person get healing, that they can share with their family for that understanding. We had a lady in that we worked with her for her application, and she went into palliative care. She wanted her story known so her kids would know, so her families would know that there was a history that made her the parent she was. And sadly, she passed away. So we had to engage with the family about what was in the application. So they're some of the complexity of the work that we do, because we're not just pushing an application, we're forming relationships through this partnership with government so we can help survivors, not only with an application, but with their healing.
Now we're going to need to, thanks David, we're going to need to finish up. I just want to acknowledge the work that you all do as individuals and a collective. I certainly enjoyed my visit last year, meeting all the staff and hearing in detail all the great work that you do. I want you to thank you for your attendance today. You'll be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors. Please send your responses to any questions taken on notice during this hearing to the Secretariat by the time that the Secretariat will advise. And we can now suspend the proceedings. Thank you.
Thanks.
Rachel. I will introduce myself. I'm Jodie Ballier, the Chair of the National Redress Committee and also the Federal Member for Dunkley, which is in Victoria. Dean, would you like to go next? Dean, you're on mute.
My name is Dean Smith, the Liberal Senator from Western Australia and the Deputy Chair of the committee.
Renee?
I'm Renee Coffey, the Federal Member for Griffith in Brisbane.
Is anyone else there? David, are you there? Richard, are you there?
Yes, Senator Richard Dowling, Senator for Tasmania.
Thank you. I would just like to read out an introduction. We'll now resume proceedings, which I think that's clicked in. I'm now called representatives, and Rachel, I hope I don't make a mess of this. Warringah Bayer Aboriginal Women's Legal Centre to give evidence today. And for the benefit of...
Good afternoon.
Rachel, sorry. Can you hear me? Rachel, can you hear me? I don't think she can.
Good afternoon. Sorry, I think I've still got my live stream on, which means I'm getting an echo. Can you hear me?
Yes, I can hear you, Rachel. For the benefit of Hansard, would you please state your full name and the capacity in which you appear before the committee? Rachel, did you hear what I had to say?
Yeah, my apologies. Can you hear me now?
Yes, I can.
Yeah, sorry, I still had the live stream on, so there was an echo in the room, so my apologies.
That's all right. Can you state your full name and where you're from?
Yeah, so my name is Rachel Martin. I'm the Principal Solicitor of Warringah Bayer Aboriginal Women's Legal Centre.
Thank you. This hearing is a legal proceeding of the Parliament and has the same standing as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Do you wish to make an opening statement before we proceed to discussion?
Yes, thank you. I will. Thank you. So thank you, everyone. I am on the unceded land of the Gadigal people of the Eora Nations. I pay my respect to elders past and present and to any Aboriginal and Torres Strait Islander people in this session. I also want to acknowledge the strength and resilience of Aboriginal women and children who have experienced child sexual abuse. So for those who don't know us, Warringah Bayer is a not-for-profit New South Wales statewide community legal centre for Aboriginal and Torres Strait Islander women and children, and the focus of our centre is to assist victims of violence, which includes, of course, child sexual assault. Our core work includes providing free legal advice and casework to clients, as well as running community legal education sessions and engaging in law reform work. Our service is managed by Aboriginal women. Our governing committee is made up entirely of Aboriginal women. Our CEO is an Aboriginal woman, and we have a number of Aboriginal and Torres Strait Islander identified positions. We provide gender-specific services sensitive to the cultural needs of Aboriginal and Torres Strait Islander women who have been victims, survivors of of violence, which includes child sexual abuse. And we also work extensively with Aboriginal and Torres Strait Islander women in custody. Many of our clients have experienced child sexual assault, and whilst most have experienced child sexual assault within families and community, a notable number of these clients have experienced child sexual assault in various institutions, including juvenile justice centres, in care, schools and religious institutions. We have assisted some Aboriginal women with redress applications, but nowhere near the volume that other legal services such as No More, and therefore we don't claim to have a deep knowledge about the scheme itself and the problems that have been identified by No More and the Auditor General's report. What we are concerned about is the lack of knowledge about the scheme through our advice work, with women, whether it be women in custody or in the community, and they're either not being aware of the scheme itself, or they're not aware that they are eligible for the scheme because there was an institution responsible for the child's sexual abuse. We do regularly provide advice about redress and civil litigation options when we identify an institution, and often there's a long history of trauma involving various institutions and family members. As I think was highlighted by NOMOR previously, I was listening into the NOMOR's evidence before, a lot of people in custody have missed out on the scheme. It was only really since 2024, the 2023 reforms, that they could access the scheme. And many Aboriginal women, certainly that we've spoken to, understood that they weren't, this is something that they couldn't access until 4th of April 2024, unless there were exceptional circumstances. The National Redress Scheme did not accept applications for redress for people in jail. In short, we recommend, and I understand, of course, there's going to be a number of questions, but in short, what we're recommending is that National Redress Scheme's operation be extended. That is, the time to make an application be extended, preferably indefinitely. That the National Redress Scheme be extended to allow children and young people under 18 to apply. The requirement that the violence that occurred prior to 1 July 2018 in order to access the scheme be removed. That there be meaningful investment in resources directed towards the distribution of information and assistance for Aboriginal and Torres Strait Islander communities and women in custody to apply to the redress scheme by way of a planned engagement process, and that the requirement for people who have served imprisonment of 5 years or more for a single offence other than certain offences be removed. Thank you.
Thank you, Rachel. Appreciate your summary. So I'll start with the awareness raising and education piece about the scheme. You talked about a lot of people in custody have missed out on redress and that people don't necessarily understand the schemes there and available. How would you suggest that we improve awareness, particularly in minority groups or groups like First Nations people or women?
I mean, the strategy needs to be multi-pronged, and I'm aware of the fact that there was fair bit of evidence given by NOMOR about this issue in terms of engaging with communities at a very local level. And this process takes a long time. It's about developing trust. It's about developing education resources that are relevant to that particular community. That there needs to be, that you're talking about not just about going out and delivering community education sessions in person. It's about developing resources that can be utilised on social media platforms as well as other mainstream platforms. It's about resourcing services on the ground to also advise and to work on developing knowledge within communities. In terms of accessing prisons, that's been a real issue for us. We have struggled to convince correctional centres to go in for us to talk about redress and how the scheme operates. When we get an opportunity to talk to women in custody about redress, even if it's just an aside, we find there's an enormous amount of interest in redress. But we think that there needs to be a specific community education program that targets people in prison, and it needs to be a constant, because as we know with people who in prison, they cycle in and out of prison at any given point in time. So you need to be constantly reminding people about the scheme and resourcing services such as ours and NOMOR to assist people making applications if that's what they think they want to do, if that's what's appropriate.
So just getting to the prisons and increasing education programs and access into the system so people know about it. What are the blocks for prisons letting you in? What's the block there?
Well, I mean, New South Wales, it's Corrective Services New South Wales. It's a government agency that has its own requirements, its own systems that we need to negotiate, and ultimately whether we're able to access a prison is decided by Corrective Services. It's not by us. And so we need to get permission from Corrective Services and the individual correctional centres to be able to enter their prisons for education purposes. And so that's a decision made at an agency level that that's all I can say, really.
How could this inquiry and any recommendations we prepare support your work or engagement?
Well, I mean, any correspondence with the New South Wales government to facilitate that would be welcome. I think the issue needs to be identified as being really important, and to recognise that there is a real need to get this information out there, and that community education is critical and integral to getting that information out there, and that to identify that services such as ours and no more are available to deliver those services, and to make that delivery seamless. I mean, obviously, there's got to be checks and balances. We understand that. We understand that there's got to be certain systems to allow delivery of community education in custodial settings. But any support to say this is really important, and that I suppose from us to understand what are the blockages? Why is it so difficult? I mean, we don't really know, to be honest.
Okay, thank you. Do any other members of the committee have questions for Rachel? That's a no from David. Renee.
Yeah, just a quick one.
Thanks, Richard.
Is the thinking about accessing the scheme from being in prison, is it universal across all prisons, or do some institutions have better pathways to help prisoners access the scheme that others could learn from?
Not that I'm aware of. No, I mean, obviously we only work with women in custody, so most of the correctional centres are male specific. So yeah, I mean, I can't sort of point to a particular correctional centre that says this is the an ideal program. This is the best way to do it. It does vary from, as I said, it varies from centre to centre, and I mean, we know there's a lot of competing education programs within prison. We're competing against other programs being delivered to people in custody, and they've got to fit us in. But we know that when we've been able to get into to do work with women in prison on other topics, it's been really welcomed by the women in custody, and they've really and we've been able to we've got lots of clients who are in custody in a range of different issues. So once we're in, we found that our education programs have been really successful, but the topics that we deliver have to be approved by corrective services, and so we've just found some resistance to redress, and we're not sure why.
Okay, that's interesting. So you can tangibly say that when you do go into a corrective facility, your intervention has delivered sort of a pathway for redress justice for people that wouldn't have happened if you hadn't been there.
Yeah, indeed. I mean, yes, I mean, women will come up and talk to us. We will get their information. We will then call them back We are on the New South Wales, the cattle system, which is it's a series of approved telephone lines where people in prison can make external calls, and we have a specific number where women can call us for advice. Women are regularly calling us on that line for advice. We are then organising appointments to speak to them in custody through there's a whole system here that you can do that in New South Wales where you can schedule appointments. So we're regularly giving advice to women about issues that are relevant to redress. The other thing that I suppose that what we're finding, which is why we wanted to press the issue about women not always being aware of redress, is that often when they're talking to us about a range of different issues in terms of history of other violence they've experienced in their life, whether it be violence within prison itself or violence by other perpetrators, they often disclose to us that they've experienced sexual abuse in an institutional setting. But not even aware of the fact that, that they might be aware of redress, or they're not aware of the redress scheme at all. But if they are aware of the redress scheme, not actually thinking that they may be eligible for the scheme. It's just almost like as if it's just, oh, by the way, I experienced this sexual abuse, for example, in a juvenile justice centre. And that's when then we're able to introduce the advice to them about their options in terms of whether it be redress or be exploring the civil claim option. So it's often, sometimes it's incidental, but once we're in and we're spreading the word, then this information needs to settle. They need to consume it. They need to think about it. They may not be ready to disclose at that point in time, of course. We know that disclosures of child sexual assault take many years. The Royal Commission made that very clear. And so it might be not that immediately they want to talk to us about what happened to them in an institutional setting, but, days, weeks down the track, they will call us and start talking about other things, and then at that point ready to talk about what happened to them in their childhood or what happened to them in this particular setting.
Right. So how do you get access to a particular correction facility now? You all go through the department. Is there some sort of structured way? Because you say that you're having difficulty getting there for redress.
So we speak. So there's obviously layers of bureaucracy, and so sometimes you're dealing with corrective services. And a particular team within corrective services. Sometimes you're dealing with them plus and or the governor of the correctional centre.
Yeah.
It depends on what you want to do and what you want to, is it a regular program? Is it a once-off visit? So sometimes we do once-off visits. We'll go to other correctional centres, and just say, look, we want to come out and have a chat to women in custody. So it might be a once-off thing. Then there's regular programs where we're going out on a very regular basis to deliver education on a variety of different topics. So it depends. It really depends on who they say that we need to talk to, and who they say that we need to get approval from.
Okay, I guess that's why, as you say, it's quite coincidental sometimes how people actually come and find access to the scheme then.
Mm. Yeah, I can't speak for. Obviously, I know that. I'm aware that No More does a lot of work with people in prison, but I don't pretend to know how that works in any great detail. But I do know. They're also a national service, so they're trying to cover the whole country. But we're just, I'm really very focused on female correctional centres or correctional centres which have some female inmates, because that varies from time to time too, at various points in time. So some regional correctional centres will have some women in custody, and then other times they won't. It just depends on any given point in terms of the prison population.
Okay, thanks.
Any other questions? Dean? No? David.
I do, Chair. Yeah.
Thanks.
So I want to thank Linda for all the work you do.
Thank you, David.
I suppose cohort of women in prison in particular, what are the particular barriers about getting to women in prisons, and how do we think about properly resourcing that?
In terms of us, accessing them, or
well, just I mean your knowledge of them as a cohort.
Yep.
Have only recently sort of become available for redress, often having multiple traumas, family domestic violence, systemic abuse, like some of the most hard to get access to justice.
Yeah, and often, I mean, I assume I'm stating the obvious here that often a lot of the women in custody have very long histories of trauma that begins from early childhood to probably literally the days before they enter the correctional centre. And so they've all got competing interests in terms of what's going on in their life, and often, and depending on at any given point how long, why they're in custody, and how long they're going to be in custody for, they have.
Can the people from the Healing Foundation turn their microphone off? Hello.
And I think it might be link up too.
Link up. Hello. Hello. Oh.
Well, will I just keep on going? Or?
Yeah.
Sorry, Senator Shoebridge. So they've often got very complex histories of trauma. So at any given point, their priority might be, how do I get out of custody? And so they then they then might be, depending on if they're in long term, they are then able to talk about the other issues that have gone on, that they've experienced in their life, which is when they want to talk about experiences of violence and any sort of any remedies that they may have. They also are talking to us about stuff that's going on for their children as well. So we might be dealing with issues around children in care or contact with carers. And so the point is that women have lots of stuff going on in their lives, and they might be dealing with homelessness, they might be dealing with addressing addiction issues, which ultimately has been caused by their experiences of trauma. There might be significant impacts upon their ability to read and write because education has suffered because of their experiences of trauma. So there's real issues around literacy. They may be in fact homeless when they exit prison. They may have nowhere to go. They may not even have access to a phone if they exit prison. So it makes it very difficult for us to keep in contact with clients as when we're trying to assist them with a legal matter. And so we often have clients that are cycling in and out of custody because life is very difficult and very unstable for them. And so often when they exit custody, we will lose contact with the client and are not able to pick that matter up again, unfortunately, until they return to custody, because we're able to check to see if they're in custody or not. We're a service based in Sydney, so we are speaking to women across the state through mostly by phone, but obviously some of these clients, when they exit prison, go to their hometown, which could be, hundreds and hundreds of kilometres away from Sydney. And so there may not be any on-the-ground services that can assist them with, for example, with a redress matter. So we're there reliant upon trying to be able to help them by phone, by post, by email, the best way that we can to make things happen. If we can find a local service that can support them to do some of these things, then obviously we will do that. But we've also had clients, of course, who we've had many clients where we start talking about their experiences of child sexual abuse, and it gets to a point where they just can't, that it's too stressful for them. They're too triggered by the conversation, and the conversation stops. And in fact, don't want to engage with us anymore because every time they talk to us, it's too difficult for them. So it depends at any given point in time, I suppose, in terms of where they are in terms of their own emotional well-being and mental health, as to whether they're able to even engage with us and engage with a system, a legal system that is talking about some of the most terrible things that has happened to them in their life.
Yeah, so I suppose part of my question is, do you get funded to follow through that complex journey with them? Because you may well start a conversation at one point, then trauma or other chaos in their life may shut it down. You have to find them again, restart the conversation. It's time consuming, it's resource consuming. Does your funding package acknowledge that?
Well, I mean, we're not specifically funded to do redress work. We're a community legal centre, so our core work is working with victims of violence. So look, it would be great if we were able to employ more people to go out to community and to do this work on the ground, whatever model that would look like. We need whole teams of Aboriginal and Torres Strait Islander specialists also to work with our clients to address their non-legal needs, to enable them to remain engaged with us in terms of our legal work. Because if people are homeless, if people are hungry, if people can't find any appropriate healing or counselling services, then they don't want to work with us as lawyers to do their legal work. So, sure, there's always a need for more resources to do a better job. We do the best that we can with what we have, but this is. When you're working with a client, you're working with them over many, many months, if in some cases years for some of our clients who have cycled in and out of prison. You have to have the staff to be able to do that and maintain those relationships long term. And certainly there's been periods of time in our life where our funding has fluctuated. It's probably the best that it's been for some time. But is it enough? No. And I think the thing about redress is that it's an unknown quantity. We don't know how many people still are out there who probably are eligible that we should be able to assist until we get out there and start doing more work and doing more community education. And we suspect there's many, many people out there. And I think clearly that's what Nomor was saying as well. But we don't know, and so it's hard to, and so it's like as if we need to get out there to speak to people to find out. But if we don't have the staff to actually get out there to do more community education work, then we will never know. And therefore, what we fear is that a whole heap of certainly Aboriginal women for us will miss out on the scheme, being conscious of the fact that the time limit's about to. It's just over 12 months before the scheme closes in terms of being able to make an application.
What we heard from Nomor and what is apparent from some of the other submissions too is that arbitrary deadline is going to fall particularly harshly on the most vulnerable, the most hard to reach cohort of survivors. And, in my mind, I'm thinking First Nations women, particularly First Nations women with history of trauma, are probably going to be unfairly, disproportionately impacted by the harsh timetable, or the arbitrary timetable.
Yep. And I would agree with you, Senator. The fact that so many Aboriginal children are, for example, are in the care system have been and continue to be so. A lot of sadly a lot of the abuse that the women that we do speak to often, unfortunately, has happened in out-of-home care. And so, if you look statistically, this makes, it makes sense. There's lots of, if you just purely go by statistics in terms of number of Aboriginal children who have been in care, and certainly a lot of the women there's a very strong connection between experiences of being in the care system and then entering the juvenile justice system and then the adult correctional system, that it's likely that there's many Aboriginal women out there who have experienced sexual abuse while, for example, in care, that have not come forward to disclose their story and therefore will miss out on the redress scheme. We also talk to we've had a number of clients where they've experienced sexual abuse in juvenile detention centres, and have not come forward. They've told us, but have not disclosed that to anyone else, and are not yet ready to talk about that either. And then unfortunately have then sadly gone on to experience sexual abuse as an adult in the adult correctional system as well. So there's layers and layers and layers of trauma, and being able to disclose that takes time. And if you're only finding out about it now and talking about it now, you haven't got much time to make an application for redress.
It takes time, but also trust to talk to somebody in a potential position of authority to engage with an institution like redress. It also takes trust. Now, you heard from No More that they were, and I commend their work, getting out into different communities, getting the APY lands, getting out to remote communities and having that outreach. But then there may well be other cohorts that want to see First Nations run and controlled organisation as a more trusted space. How important do you think it is to have in those sort of multiple ways for people to reach, including through organisations like Warringah Bay?
Yeah, that's essential, Senator. It's essential. Obviously, it is about absolutely trusting an Aboriginal Torres Strait Islander organisation and needing to see your own people on the ground to talk to for you to share your stories with, to be both obviously culturally appropriate, but culturally appropriate and specific to your community, wherever it may be. And trauma informed, but also for our services, also gender appropriate as well, because we're obviously, the needs of women are different to the needs of men. And there's a place for all of us, because obviously, there's complex families with different needs, and in some cases we can't assist whole families for a variety of different reasons. So there needs to be other services on the grounds to support those people, because perhaps we can't do it because there might be conflicts between various individuals. So there's a need for many services many legal services or support services to assist Aboriginal and Torres Strait Islander communities. But it goes without saying that having an Aboriginal controlled organisation that takes time and is respectful, and to build trust is essential. And we have been doing that over our years, and we started off as a very small organisation that has grown over time. But still, there's parts of the state that we cannot get to, because we just don't have the people power and the resources to do it, and to do it frequently. It just can't be a once-off visit. You've got to go back and back and back and back to build up those relationships, to build up that trust. And that's, you know, I mean, we just don't have the budget to do that. So, yes, I mean, you know, a lot more money is needed to do that well.
Rachel, I'm conscious of time, and I suppose I'm interested in your top 3 recommendations for us as we move forward. I've certainly been writing a number of notes. What would you say to us are the key things, take-homes for us?
Well, as you probably can gather, we think the time limit to make an application be extended.
Yeah.
Preferably indefinitely, but it needs to be extended. I mean, we also that, you know, that there needs to be meaningful investment in and resources directed towards
prisons,
education, and support for Aboriginal and Torres Strait Islander communities that do, you know, to engage in the National Redress Scheme if that's what they so choose to do. Number 3, I don't know. I mean, I think that, I mean, I'm going to repeat 3 and 4. I think the scheme needs to be extended to allow children and young people under 18 to apply. We don't understand why that is the case. I mean, we, for example, have a client where she won't turn 18 before the scheme finishes, therefore she will not be able to apply, even though her abuse occurred before 1 July 2018. Yeah, so, yeah, I mean, you can combine those 2 points. The scheme to be extended to allow children and young people under 18 to apply, and that the requirement the advance occurred prior to 1 July 2018 in order to access the redress scheme be removed as well. So we also think that was an arbitrary line that was drawn, and we think it's also deeply unfair that if your abuse occurred before 1 July, sorry, if your abuse occurred after 1 July 2018, that you can't, you're not eligible for the scheme as well. We think that's really deeply unfair as well, because I mean the abuse is continuing. Unfortunately, it's still continuing.
Rachel, I just want to thank you for the work that you do in the community, looking after women and the First Nations community. So I appreciate that the work that people do in community and in this space is very deep and difficult work at times, requiring lots of care and empathy. So thank you for that work that you and the organisation do. You will be sent a copy of the transcript of your evidence and will have an opportunity to request any corrections to transcription errors. Please send any responses to any questions taken on notice during this hearing to the Secretariat by the time that the Secretariat will advise. But yes, thank you very much for your contributions today. Would anyone else like to say anything? David, did you want to say anything?
Oh, no, I just wanted to thank Rachel and the team, and could you pass on our gratitude to everyone at Moringa for the work they do. I'm expressing my gratitude, but I'm pretty sure I'm expressing the whole committee's gratitude. Really appreciate the work you do. We know it's not easy, and it's vital, so thanks.
Thank you. Thank you.
Absolutely.
Thank you,
Thank you, committee.
Thanks.
Thank you so much.
Bye-bye.
Bye.
Just suspend for a minute.
And we'll suspend the hearing for a few moments. For the wait. I'm Jodie Ballier and I'm the chair of the National Redress Committee, and I come from Victoria, from Dunkley, which is near Frankston, and I will get my colleagues to introduce themselves. Renee, would you like to go next?
Certainly. I'm Renee Coffey. I'm the federal member for Griffith up in Brisbane.
Thank you. David?
Yeah, David Shoebridge, Senator for New South Wales.
Wonderful. And I don't think Dean's here at this stage. So I'm just going to read out an introductory statement. So I'd like to welcome you all here. Oh, Richard, would you like to introduce yourself?
Yes, apologies for the delay. Senator Richard Dowling, Senator for Tasmania.
Thanks, Richard. I now welcome representatives of the Healing Foundation to give evidence today. For the benefit of Hansard, would you please state your full name and the capacity in which you appear before the committee?
Leonie Melzer-Williamson, Deputy CEO of the Aboriginal and Torres Strait Islander Healing Foundation.
And Nicole Kilby, Director of Policy and Programs at the Healing Foundation.
And we've got people online, and so from Link Up and Kaya, would you like to introduce yourselves?
Good afternoon, my name's Lynn Kingan. I'm the CEO of Link Up New South Wales Aboriginal Corporation. And I'm Donna Carroll, Senior Redress Counsellor with Link Up New South Wales.
Thank you. And Kaya?
My name is Kaya Leonard. I'm the Social and Emotional Wellbeings Manager with Link Up New South Wales.
Wonderful. Thank you all for joining us today and for your submission. This hearing is a legal proceeding of the Parliament, and it has the same standing as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Do you wish to make an opening statement before we proceed to discussion?
Yes, please, Chair, if I could. So, thank you, Chair and Committee, for having us here today. I'd also like to add my acknowledgement to the Ngunnawal and Ngambri people as the traditional owners of these lands, and also to the stolen generations whose legacy our work is informed by. So, the Healing Foundation is a national organisation established in response to the Bringing Them Home inquiry. We exist because the inquiry elevated the voice of stolen generation survivors and made clear the direct link between forced removal, institutionalisation and exposure to abuse, as well as the profound intergenerational trauma that followed on. Nearly 3 decades on, only 6% of the Bringing Them Home recommendations have been fully implemented. The unfinished business continues to shape the experiences of stolen generation survivors today, including their interactions with the National Redress Scheme. Do you want to jump in? Yes,
yeah, sure. So through our work with survivors and Aboriginal community-controlled organisations across the country, we continue to hear that many elements of the scheme remain bureaucratic, re-traumatising and culturally unsafe, particularly for stolen generation survivors who already carry deep mistrust of government systems. Our key message to the committee is that the scheme must be extended and it also must be reformed. So extension alone is not sufficient unless it's accompanied by meaningful changes to how the scheme operates in practice, including transparent and consistent decision-making, trauma-informed practice embedded across all stages, culturally appropriate and accessible application pathways, and proper investment in Aboriginal community-controlled organisations supporting survivors before, during and after redress. So we've invited Lynn Kingan and the New South Wales Link Up team to join us today because Link Up organisations are on the front line supporting stolen generation survivors through the National Redress Scheme every day. Chair, I'll now hand over to Ms Kingham, who will share New South Wales Link Up's frontline experience supporting survivors through the scheme.
Thank you, Leonie. I'd also like to acknowledge the traditional owners of the land of Darug Nation, which I meet on today, and I'd like to pay my respects to the elders past and present. I'd also like to acknowledge any Stolen Generation survivors that join us today, and all Stolen Generation peoples. I guess Link Up New South Wales was established in 1980 to reunite the stolen generations. We've been doing that for 45 years as part of our programs. We do the National Redress Scheme. What we're seeing and what we're learning from our survivors is that the process is not simply administrative, that it's a deeply personal and often traumatic experience. For many of our survivors engaging with the scheme, it requires them to revisit experiences that they've spent a lifetime trying to contain. In doing so, we're lifting the lid on sometimes decades of suppressed trauma. Survivors often describe it as taking the lid off or opening Pandora's box with no guarantee that the support available will be sufficient to hold what comes out. I want to emphasise that they're not isolated impacts, they're detrimental impacts that are caused by the past policy, which continue to affect our survivors today and compound intergenerational and complex trauma across all families and communities. We're increasingly hearing from our survivors who regret engaging in the process, who tell us they wish they'd never started because they feel more traumatised or re-traumatised by the process. It's particularly evident in the periods post-application and post-outcome where the lack of structure or trauma-informed aftercare is most critical. Survivors are left to process not only their past but the emotional impact of the scheme itself, and often in isolation. As an organisation, we're learning that the trauma doesn't end with the payment or an outcome letter. In many cases, that's really where the real work begins for us. We're also seeing clearly that intergenerational trauma is not being adequately addressed. Survivors often carry the burden that not only for themselves but for their children and their grandchildren. At the same time, they hold deep shame and stigma, trying to protect their families from their story and creating silence, disconnection and ongoing cycles of that trauma. There's significant impact on those supporting survivors, so our staff who experience the vicarious trauma, holding these stories and walking alongside our survivors, often without adequate resourcing or support. We're deeply concerned about the inconsistent outcomes within the scheme. We've seen cases where we've involved siblings, brother and sister, who've experienced abuse in the same institution, same perpetrator. The brother received maximum compensation available, and the sister who experienced the same sexual abuse was denied redress. For survivors, this reinforces the words of perpetrators that no one will ever believe you. I guess when one story is validated and another is not, that message is repeated. Survivors are left re-traumatised, feeling once again unheard, unvalued, not believed, unjustified. I guess when the compensation is awarded, it does not heal the wounds that have been reopened. Our survivors are telling us they need more than a process. They need culturally grounded healing, connection to identity and culture, and to community, and they feel valued. They need to feel valued as Aboriginal people, not just applicants. I guess in response to that, Link Up New South Wales has sought separate funding from that of the National Redress Scheme to support a different approach for our clients. So in June this year, we will take 20 Aboriginal National Redress survivors to a culturally led healing camp incorporating therapies such as animal therapy, narrative therapy, art therapy, men's and women's business. And we're focusing on reconnection to culture and identity. And I'd also like to acknowledge that Donna, who's sitting beside me, was the one that has facilitated, and it was her guess it was her dream to do this with the National Redress Scheme survivors. So it's something that we're proud to take the lead on. We need to, culturally significant healing needs to be included, and it's not embedded or adequately funded within the redress framework. If we're serious about supporting our survivors, we need to recognise that financial redress alone is not enough. Without meaningful, cultural, appropriate aftercare, we risk causing further harm if we don't provide it. Survivors deserve more than this process. They deserve support along the journey, before, during and after, and it needs to be culturally safe and trauma-informed care. When we're asking our survivors to reopen their stories, then I believe we carry the responsibility not just to hear them, but also to help them heal. Thank you.
Thank you very much for that summary. I do like the sound of that cultural healing program. Sounds amazing. So I think you've given us a summary of what you'd like. Have you got some specifics around what's not working and then what is?
Through the chair. Lynn, did you want to address that first, or did you want us to...
No, you go, Leonie, and then I'll get Donna to write me some notes here.
Yeah. So, look, I think there is a few things that's not working that Lynn's touched on in there. I think that the culturally safe support, there is just not the support around the person, the applicant, whether they're successful or they're not, in terms of both the information provided to them, and, you know, opportunities to heal, but also I think referral processes, and Link Up New South Wales can speak more knowledgeably about the wait times, the information for survivors, and I'm sure the committee would have heard this several times, Chair, that the confusion for stolen generations survivors specifically when they operate within class actions, redress schemes for survivors, the national redress schemes, and then you have lawyers. When we do have trusted organisations such as the Link Ups out who work with survivors, I think that helps. So, you know, supporting Aboriginal community-controlled organisations who have established relationships and places of trust for survivors is one thing that we are working. One of the big challenges that we hear over and over again, and I'm sure the committee has heard before, is regional and remote support, with the amount that they are funded for applicant support and the regions that they'll have to travel. And Link Up New South Wales can speak to this in terms of their service area, but we hear a lot about this in, you know, obviously WA, the Kimberleys, WA, the southern regions of the Kimberleys, Northern Territory, and pretty much most of the areas. So I think there are a few of the key areas. Lynn, might hand over to you.
We just talked to wait times. I'm interested to know where you think there are blockages in the system that perpetrate those longer wait times for people. And yes.
Lynn, is your team able to speak to that a little bit more about the delays that you have around the processing and the application process?
I'll talk about that, Donna, or Kaya. Kaya can you? Kaya?
Yes. Can you hear me okay?
Yes, we can hear you.
So some of the effects of the timeline, I guess, we're starting to see that we're actually losing clients. There's clients that are passing within this time frame. Their families are not able to then consume those funds due to that passing, and there is, I guess, complexities towards that in terms of nominated persons. And we see that as well because we hold concerns for, I guess, management of those financials once they're distributed. However, we're seeing within this time frame that there are significant changes such as to their ongoing complex lifestyles. So we're working with people that have relationship breakdowns They're dealing with homelessness, they're dealing with domestic and family violence, they're dealing with all these ongoing factors that are continuing to contribute negatively towards their lifestyles. So within these timeframes, it's prolonging any substantial change to occur within that time as well for them. I guess because they do hold some type of, I guess, hope that this money will somewhat change their lives. And then once they have the money, I guess it's how they manage that once they get to that point. However, it's this within this time frame, so many factors are occurring that you can't really put your finger on one. There's so many different variables. However, those are just a few that I can think of.
So the wait times and which mean that people are passing before they're given their redress.
Yes.
What's that due to? Do you have any specifics? Are there different things within the system or the process?
Yes, at times it's terminal illness. One of the most recent, I believe, was cancer. However, we do currently have a client who is within the palliative care system, who, I'm sorry, you can correct me if I'm wrong, Donna, who is currentently suffering with cancer, I believe. Other direct, I guess, other ones is the fact that they're old. We're working with people that are at the age where, they've dealt with everything. Now they're at the stage of their lives of opening up. So they're ready to, I guess, have that closure for themselves when they do pass.
Kaya, I think sorry, apologies if I haven't explained myself. It's what are the systems issues that are creating the blocks from people being given redress earlier? So where are the blockages in the process along the way for First Nations people or, clients?
Yeah, sure. Yeah. So there are, I guess, it's 24, so it's where the independent decision makers are requesting further information. It's that back and forth where between our clients and our caseworkers it isn't effectively being able to have all the information up front. And I guess that's where the client isn't ready to give further information either in their current state.
Sorry, Kai, if I can interject, I think just from some of the notes from our earlier discussions that New South Wales provided some of the administrative pieces about, small pieces of information, bank accounts, incorrect information, and the time that was taken to resolve that. If that's correct, sorry, in the representation of some of those pieces, that just small mistakes take a long time to resolve and delay the process.
Yes.
Yeah.
I'm going to hand. Sorry, Kaya. Did you have something else to add?
I was going to include with the change of names, birth certificates. You've got you have people that are dealing with Centrelink that have limited access to technology and also limited literacy and numeracy skills here. So there's so many impacting factors there as well.
And I imagine some people may not have birth certificates. Yes? Yeah.
You are correct.
So I'm going to hand over to my colleagues. Is there anyone online that would like to ask a question? Thanks, David.
Thanks, Jan. Thanks, everyone, for coming. And sharing your experience. But it is really troubling to hear about the scheme in re-traumatising. And one of the issues that keeps coming up is the inconsistency in decision making. IDMs, one IDM with the exact same circumstances, approving and making a making a determination for compensation than another family member missing out with the near identical circumstances. You gave one example to that effect. How common is this? And can you give us some other sort of, edited examples that give us an understanding of what's happening to your clients?
I think another one of the cases was of a survivor who had some intellectual challenges, was born with intellectual challenges, removed, put into a home. The perpetrator was not of that institution, but it was the institution's duty of care, knowing that she was easily persuaded and sneaking out, at night. I think at the age of 16 or 17 from memory, but potentially had the mental capacity of a 12-year-old at that stage, and it was declined or denied because the perpetrator wasn't within the institution. But the institution had duty of care over her to make sure that she was safe within the institution, knowing that she was easily persuaded out of the institution with something, and I'm not sure of the exact details here, but something as simple as come and see the puppy in the car. Like, she had the intellectual the intellectual challenge of being able to be persuaded quite simply that the body of a 16-year-old, and then was subjected to abuse outside the institution, but it was denied on the fact that the abuse didn't happen within the institution. So that was another one that stands. There was also, and I'm just going to mute myself, I'm going to say the name of the client to Donna. I'll get my paperwork.
Chair, if I may
that's
just
okay.
add that
Leonie.
this is really something common that we hear as the Healing Foundation. We're not a service provider. We do get a lot of the stories from the Stolen Generation organisations, but also when we come into contact with survivors, I've heard firsthand quite similar cases, involving through groups of siblings who went through quite a similar scenario because of the case it was, two received it, even though what they described, what they experienced, it was within the same service at the same time, same period, very close period. And yeah, there was, and I did sort of try and ask why they hadn't, what information they had about why they'd been returned or what access they'd had around repeal services, and it's often just difficult to unpack, at that point in time when people have been through a system to that end as well. Yeah.
Yes. Sorry.
And is it your
you go, David.
In the sense that this has been improving or it's been getting worse? The inconsistency in the decision making?
Yes.
Getting worse?
I don't think it's getting worse. I don't think it's getting better, though.
It's interesting. Can I just add to this line of questioning that we've heard in the early stages, there was a difference between likely and probable, and it feels like, as we've heard people speak today, that the use of probable has been the lens that's been more recently applied to decisions, so that if people were coming from the same institution at the same time and a situation had taken place, there was a probability that people experienced the same thing, but likely, I believe, was the filter that was used earlier on. And I suppose I'm just trying to work out the inconsistencies or the consistencies around that. David, did you have anything else to say to that? And then Renee's got her hand up.
Well, I suppose, you're picking up these inconsistencies from your client. It seems remarkable that there isn't some kind of system in the redress scheme where there's some review where they have common alleged perpetrators, common institution, some kind of systemic review to pick up the inconsistencies before they're delivered and traumatised clients and survivors. Have you asked the scheme about this? Where a complaint's been made, a review's been filed? It's not your job to fix the scheme, but I'm just wondering what your knowledge of it is.
Would that be covered in the NRS meetings that you have? Yeah, it does. Yeah. Yeah. So they have NRS meetings where they can cover complaints, concerns, challenges, and they can discuss them with people from the scheme. Michael, from the scheme. Yep, they discuss those with people from the scheme. But again, like you said, we can't fix the scheme. All we can do is report what inconsistencies and challenges we're facing. And when I was part of those meetings, it was the same inconsistencies and the same challenges being met by most organisations, definitely most Aboriginal organisations.
Through the chair, could I add to that? I think that's a good pick up on the data. I think that goes to where the evidence burden sits, whether it's with, the survivors, the applicants, or, the scheme administrators or the institutions themselves. But one of the things that we've put forward in our submission is that we think there's a whole wealth of information in there in the data and the data review, and that it should be the responsibility of the department and the government to undertake, a review of the applicants, especially given the number of Aboriginal and Torres Strait Islander applicants, to look at what's actually happened to the applicants, what have been the assessment processes, the outcomes, are there cases that need to be looked at again, but also what we can learn and know. And I know that there's a whole lot of administrative regulations around how that, data is used, but there is really important information in there about, institutions who, were very active in the forced removal of Aboriginal and Torres Strait Islander children, and the records they have, the histories they have, that information just isn't available. And so one of the big pieces that we have put forward through to the department is about what's actually happening around, that information that's known, how that's been reviewed, and how that's been thought about in terms of understanding, our history and what actually happened to stolen generations.
I would love it if you had some more details to give about some of those interactions you've had with the department. For me, that at the stage the scheme is at, those sorts of recommendations about what we do with the information gathered, what light it shines upon what communities need, particular, extra services and resourcing, but also capturing some of that history for communities. Thinking about that now, because the scheme goes over the chaotic last couple of years, I think is critical. If you wanted to give us some more insight into what you think could be captured from the scheme to help communities post-closure, I'd really appreciate it. If you have the chance to give us some more details on those.
Yeah, I'm happy to provide that.
Renee, you've got your hand up.
Yes, thank you. Thank you so much for the information you provided and all the work that you're doing in community. I'm just wanting to drill down a little bit more into the idea of cultural safety and cultural competency, a theme that comes through in your submissions. I'm wanting to understand over time, and as the scheme has matured or as time has advanced, whether you've seen a change in cultural safety and cultural competency from the scheme and how they approach their work with First Nation cohorts.
Link Up New South Wales, can I hand that one to you in the first instance? Happy to.
Yeah, Kaya and Donna, you're front line with this, so I can answer. Kaya?
Thank you, Donna. I guess in terms of the support offered, I've been in my position for the last 12 months, and I must say that there has been, I guess, some positive progress with our staff and having that communication open with the Aboriginal specific groups within and Donna, I'd really like your support with this one, with No More Legal, I believe.
I think a lot of it's got to do with transparency within the scheme too, when acknowledging the abuse upon the clients that we work with. A lot of them feel, how do I say it? Besides re-traumatising them and stuff like that, it's just like a slap in the face, because like, he's half money, you know what I mean? Now you got to sort of like get over it. There's no support offered after the scheme's finished.
Yeah, so some direct quotes from our clients.
Yeah.
It includes, I wish I never applied. The direct personal response isn't worth the piece of paper it's written on. You know, there's others that say, I wish I'd never been born. And that's where we're seeing that ongoing post-application.
Thank you. Do you feel that that's got worse or better over time as the years have gone on?
We're seeing as an influx of applications do come in, Renee, that this is getting worse, and we've just recently done an outreach to the Broken Hill area, Wilkenya specifically, and they're quite remote and isolated, so they were very limited in what information they had, and specifically not just the NRS but also options to civil claims as well. Our clients are telling us that they feel like they're being persuaded, although that's not the dialogue that's coming from Link Up New South Wales. However, they're saying, okay, I feel like if I don't have enough money or time on my hands, then this is just a quick, a quick buck for the government to be able to say, okay, sorry for what's happened for you in the past, but here's some quick money for you to, go and, I guess, we're working with people that are using drugs and alcohol as self-medication systems. We are working with people that are very limited in, financial competency, what to do with their funds once they're received. However, before that it even, does result, I guess that's where we're seeing that their mental health is becoming a lot more impacted negatively due to that.
I agree. Mental health is a big major factor with all of our clientele.
Thank you.
So that's during and post the process. Is that what I'm hearing? So
Yes.
we've heard about people that have received money, and once they've received money, they're not necessarily valuing it or the process.
Not that they don't value it or the process. They don't feel valued by it or the process. I guess we're seeing that it doesn't provide them with a sense of closure.
Renee, you were going to ask a question.
It goes back to me saying about putting the lid back on something that we don't know what process. There is no traumatic solution to what's going to hold that trauma, because you don't know what that trauma is when you open it. So when we're talking pre-application, the client has a perception of what the process is going to look like, and it's not until you get to the story and in depth, and we're talking to that client, that even they realise the amount of trauma that they're reopening, the wound that they're reopening, or the lid that they're taking off. And I think that's where I wish I'd never gone through this, because nobody realises until you're re-traumatised, until you're in the thick of it, how damaging the process can be for some people. And then how do you put the lid back on? Sometimes that lid just won't go back on. You can't, no amount of money, no apology is going to put that back on the shelf. And for those clients, we're leaving them, yes, with money in their bank that potentially could get humbugged or spent in self-medicating the trauma. But how do we support that client now for something that we've started? We didn't start the trauma, but we've opened it back up again, and we've started a process that has enabled that trauma to rise to the surface again and to damage these people to the point where not only mental health, but I would suggest suicide would be very high. We've certainly taken our fair share of suicide calls from people in wishing that they had not remembered the extent of the abuse until you've got them in a room and they're telling their story again. And as they remember one thing or a trigger or a smell or a look or a situation or remembering the home, re-triggers and memories about exactly what's happened, and these memories have been suppressed. So I guess they don't know about that part when they first step into, I'm going to get redress for being abused.
And a lot with all of this process and stuff too, you got to remember these Aboriginal communities have so much mistrust in government agencies as it is. So once the scheme's finished, what's left for them? They're going to be thinking the government set them up to fail again, and we're left resolved to.
So Donna, when you say that, is that about the money or not having? Is it about the money, or is it more about what services and healing and recovery services exist beyond the closure of the scheme? Yes?
Correct. Well, I think it's about the healing and recovery services that are specifically Indigenous. And when we talk about healing, we talk specifically about cultural healing done in traditional healing ways rather than in, sorry, I don't know another way to say it, white men's healing.
Yeah.
I guess in support of that as well, it's quite a specialised area to be able to counsel complex trauma. So we're limited, although we do have a counsellor on hand, we're limited in the supports that we're able to provide that post as well. As we're discussing, you know, the funding only takes us up until the client does receive their outcome. So we're really not able to provide that effective counselling support needed during that time either. However, we are trying our best, and that's where we do ensure that we do come from that cultural perspective in that culturally safe environment that we try to ensure for our clients. But in saying that, they see us as a representative of the government as well, because we're out in communities and we're informing them of the scheme. They see us as an extra arm of government, where we're also, as an agency and as people, professionally and personally, we're also re-establishing relationships every time we re-enter different communities, every time we're engaging with a new client as well. So I guess effectively what you're talking about definitely is it's the post support that's needed to meet that ongoing complex trauma that is now reopened. It's re-traumatised for that client.
I'm just going to ask, Dean, did you have anything to add or any questions?
Nothing from me, thank you, Chair.
Renee, did you have any other questions?
No, thank you so much.
I think for me, I'm conscious of time. We'll keep going until 10 past because we started it a bit later. What are the key take-homes for us as a redress, as a committee, as we do this inquiry?
I think from the Healing Foundation's perspective, the main piece is around the data, the information that's being collected, that there's clear processes in there around review, that the program does need to be extended. We do need that application process, but it does need to be changed. And I think Link Up has spoken more specifically and I think persuasively to that there's not enough of the wraparound healing and supports for survivors to avoid re-traumatisation or,
That's right, and healing is long term, and that's something that we experience, whether it's redress, and obviously the link ups and all of the stolen generation organisations are working in that space every day. It's whether it's related to redress or not, but that adds an extra layer of complexity into it. But I think the big part as well is around the transparency of the schemes, because if there's already that lack of distrust, there's the distrust from the community about what this is, and then that's adding the re-traumatisation is compiling, obviously, when they're going through this process, but that sense that we're doing more harm when they're going through that process as well is really important to consider.
Can I just ask you, when you're talking about transparency, what are you specifically talking about?
I think in our submission we spoke a lot about the inconsistent and non-transparent outcomes. So like the inconsistent eligibility determinations is something we raised. The varying redress amounts for the different survivor experience, the similar survivor experiences which have been mentioned, but deductions of prior payments related to child removal and not sexual abuse, I think, was coming through. But the lack of transparency about the access to the decision-making rationale, I think, is something that we hear a lot from the link-ups and the survivors on the ground.
Is there anything else from Link Up New South Wales that you wanted to add in terms of your recommendations?
I concur with the Healing Foundation with the extension of the scheme. I know that from our far outreach that we've done, we're going down south, is that people still have not heard about the scheme. That in remote communities, and given that we go out to these remote communities, and given that the shame and the stigma around the sexual abuse in institutions is that often the aunts and the uncles aren't ready to talk about it the first visit, or maybe even the second visit. They've got to build that trust up. So definitely extension. Resources and support, that wraparound service, is that the people that are taking the stories, the applications, I feel that organiser, they've built a rapport and a trust with that person. I know specifically Donna, they've built that with Donna to be able to provide the wraparound service where Donna can, once it's post outcome, Donna can still provide a service to them as a counsellor, but also through the healing camp. If we can maintain being able to facilitate healing camps, that we can then take that post-application healing, traditional healing, and they're not having to retell their story to another counsellor, to another person, and going through it all over again, and that it's more about the healing and putting the lid back on, would be my second one. And the third one would be the resources and support for our staff to be counsellors, not only to maintain our duty of care to our clients, but also my duty of care to my staff in the vicarious trauma. So resources and support for the staff to be properly qualified and going to workshops to ensure their own safety as well as that of the client.
Through the chair, could I just make one comment?
Of course.
No, I just wanted to share that, and I'm sure I do speak on behalf of the other committee members, that much of what you shared this afternoon has been deeply disturbing, and I'm very thankful that you shared the information, but I also, just on the vicarious trauma, I do want to acknowledge the important work that you and your teams are doing in this space, and recognise that toll of that work as well on your workforce, and just express our appreciation. Thank you.
Thank you.
Any other comments or questions? Kaya, did you want to add anything to that recommendation list?
I guess I'd just like to add, and I feel like to wrap everything up for our message that we're trying to portray is that you can't put a time frame on healing you know, and we're trying our best to come up with so many different ways that we can support our cultural healing for our clients. But thank you for your time today.
Thank you all for the work that you do. Prior to working in this role as an MP, I had the fortune of leading an organisation that provided healing and recovery programs for women post-trauma from domestic and family violence and abuse, and have worked with a lot of First Nations communities in regional settings, and so really understand and value the work that you can do out on country in helping people heal and recover. So I'm a strong advocate for Donna. It sounds like the work you've initiated in your community, so well done. Yes, we'll certainly make sure that we promote that, because recovery is lifelong, and we've heard that today from some other people that have experienced sexual abuse through institutions. So thank you all very much for the work that you do. We really appreciate your time today and your submission. I'll just finish this. I've just got a closing statement. Thank you for your attendance today. You'll be sent a copy of the transcript of your evidence, and we'll have an opportunity to request corrections to transcription errors. Please send your responses to any questions taken on notice during this hearing to the Secretariat by the time that the Secretariat will advise. And I'd now like to close the hearing. So thank you very much for coming today.
Thanks, Chair. Thanks, Committee.
Thanks, everyone.
Thanks again.
Thanks.